Okay, we are going to call this general meeting portion of the hearings. Yes, we're on the record, thank you. For the general meeting, we have a few administrative tasks to take care of before the zoning docket begins at 1. So the board will just be doing that, and you can feel free to listen in. You don't really have a choice, so. Okay, so we'll start with the extension request. Al Berry submitted an extension request for 2018-323, 1000 Eastern Avenue. He's requesting an extension because of delays, obviously. The owner was required to go through design review and changes to his plan through the planning department's UDAP process that took a year. Even with substantial COVID review delays, most agencies have signed off, but then they ran into cost increases in construction materials and financing, which have made it necessary to postpone until 2023. He's requesting an 18-month extension. I think the board can approve up to 12 months at a time. And that's all the information I have on that. Oh, and make sure to turn your microphone on when you're going to speak and bring it close to you.
So, Mike.
I am as well.
Okay, sounds like a unanimous yes of a 12-month extension for that one. All right, let's, we could do adoption of the resolutions from October 11th and then go into the miscellaneous category. So you should have the resolutions in front of you from October 11th, the contested ones anyway. So I'll go through them quickly. The first one is 2022-332, 1211 Dundalk Avenue. This is the one where the guy paved his backyard and then requested a variance. Excuse me. The board denied that application because there was no finding of uniqueness or no allegation of uniqueness of the property that would require this variance. That was by a vote of 3-1, I believe. The second resolution before the board is 1724 Druid Hill Avenue. This is one where there had been a history of this property in the distant past being a multifamily dwelling, and then it changed to being used as a single-family dwelling as assisted living. So they're asking to use it now as a multifamily dwelling. Oh, sure. Would you like to?
That's what the procedure's been.
Okay. Then let's go back to the first one.
I'm fine.
I'm a yes.
Great. Okay, moving on then to the second one, the Druid Hill Avenue case 2022-335. This was a request to use what is currently a single-family dwelling as a multifamily dwelling. The board denied that because it would be a residential conversion that the board does not have the authority to grant in this zoning district.
I'm a yes too. Sorry.
Okay, everyone needs to have their microphone on. Okay, 1810 McCullough Street, 2022-293. This was a request for a multifamily dwelling. He was asking for 6 dwelling units. There was community opposition in this case. This is a pre-existing multifamily, and the board ended up approving 5 dwelling units instead of 6, which still required a lot area variance. So the board approved that, but only 5 instead of 6.
Yes.
Yes.
And the last one, 2120 to 2122 North Charles Street. This is appeal number 2022-329. This was a request to use the premises as a tavern with live entertainment, accessory live entertainment, which would require conditional use approval and an off-street parking variance. There was testimony that there would not be any outdoor live entertainment because there is no outdoor area for this building. And that's also why they could not provide parking, because there's no parking lot. So under the conditional use and variance standards, the board approved that appeal. under certain conditions, sorry, which you can see on the fourth page there, relating to the capacity of the tavern and making sure that certain records are available for inspection on site.
I'm a yes.
Yes.
Yes, I'm also a yes.
Great, thank you. Okay. Would you like to do Bank Street first or Lancaster Street first?
Um,
I'm sorry, what did you say?
For the first two things on miscellaneous, do you want to do the Lancaster Street case first or the Bank Street?
Well, we can take that up. Lancaster, whatever you want to say.
Is your mic on?
Yes. Couple of things. Given the volume of the material, I think we'd like to take it up and read it thoroughly. Also, if you have the opportunity to have the law department weigh in for the benefit of the board, I recognize the rule stating that an appellant generally administratively has an opportunity and a right to withdraw an appeal. This has a little, sort of an involved history, but I'd like to be sure of what the rule is and how it's applicable here. And so, if the board agrees, I'd request that we defer taking this matter up and issuing a ruling on the motion for the request and the opposition until we have time to fully digest this material, as well as any weighing in from the law department.
I agree.
I agree.
Would you like to schedule it for the 6th of December?
That's fine, that's vision time.
So that's 2 weeks from today?
Hold, please.
Okay, then that will be heard by the board and decided by the board during their general meeting on December 6th. Okay, then the next item to discuss is 2022-314, 1826 Bank Street. So the board heard this case on November 1st, 2022, and wanted to have some time to review a previous matter relating to this same address. And so the board decided to hold their deliberations until this hearing. So I will let the board deliberate on that matter now.
Okay. Just want to say the quality of the video in the prior hearing is pretty bad, I thought. The volume wasn't there, so hopefully if we're in that situation again, we can make some adjustments, so when we have to review it, we can actually hear what we say. With some careful listening, I heard it and considered that testimony, but it didn't change for me where the evidence was presented here more recently. I had difficulty finding evidence supporting the factual finding of uniqueness with regard to the home. I know there's discussion about the additional evidence that Ms. No presented regarding why she wanted additional space. I recall the record evidence being that the homes in that area and on that block are of varying configurations, width, lengths, and at the end of the day, it's a request to make my home larger. That, to me, does not establish the uniqueness requirement based on my understanding of the applicable law and what we're required to find. And so, I'm a no.
I would have been a no the first time around, but no.
Yeah, I'm certainly sympathetic to the argument. My neighbors have it, so I should have it, but as you said, there were no facts presented as to the uniqueness of the property, so I'm going to be a no also.
My position is still a yes because of, I guess, the opposite of what Leland said is that, and I think I've been consistent with this, is that this property is no different than homes in Federal Hill that ask for the same thing and end up on our consent docket. And I think that's a bigger issue. And so until there's that reconciliation, I can't just say no to this one. Because it doesn't make any sense to me. It's not consistent. I don't think that's equitable or fair to Miss No and her property. Yeah.
Okay, so I hear a 3-1 vote against that appeal based on the lack of uniqueness presented. Okay. Okay.
Yeah, close.
Are you in the short one?
I must be.
Yeah, that's a short chair.
Yeah, I'm not the tallest guy in the world. Okay. Yeah.
All right, so I think the only thing left on the general meeting docket is the appointment issue that you all wanted to do in closed session. So there's certain provisions in the docket memo or certain statements that you have to make in order to do that.
Make a motion, right?
Yep.
All right, this time I would move that the board transition to a brief closed session to discuss a personnel matter. And we'll take that up and we'll be back with you directly. So we have to leave.
You have to leave, unfortunately, yeah.
Probably better if there's a lot.
But you have to say the section of the general provisions article, which is
Closed
it.
session under the provisions of Maryland Code, General Provisions, Articles, Section 3-305B1. Is that the accurate provision?
Yes.
Okay. So pursuant to that provision, we will be going to closed session to discuss the personnel matter.
And then you need you made
Oh,
the
second.
motion, you need a second.
I did make a motion.
I'll second.
All in favor?
Aye.
Any opposed? Motion carries.
Great,
Okay.
thank you.
Oh,
Oh, the conference room.
Okay.
Yes, we're off the record, thank you.
will anyone be joining us?
No, I'm not doing the
Ushering us in there.
Just us.
Can I bring my food? Yes.
I'm watching some.
All right.
I know, he's such a quiet talker. Yeah, yeah. I'll tell him to leave. Okay, we're gonna come back on the record here. Are we ready? Okay, great. So let me get my script out. Okay, good afternoon. Welcome to the 1:25 PM docket for the Board of Municipal and Zoning Appeals. We are in the Planning Department boardroom. My name is Becky Witt. I'm the Assistant Counsel to the BMCA, as well as currently the Acting Executive Director. From left to right, we have Leland Shelton, James Field, who's the Chair, Bill Cunningham, Sabrina Johnson-Turner, who are all board members. Please silence your cell phones. If you need to have a conversation with someone, please do it in the lobby or in the hallway out there. When it's your turn to speak, please identify yourself. I'm going to turn the microphones on at this podium here. You can turn the microphone on, make sure it's glowing green, that means it's on. And identify yourself and spell your name for the court reporter and be sworn in to testify. If you haven't already signed in on the sign-in sheet and you plan to speak today, please sign in now. Everyone who wants to speak should sign in, including attorneys, applicants, opposition, and support. The board's vote on your case today doesn't make our decision final. We're required to issue our decision in writing in a document called a resolution, which is a process that takes some time. The resolutions need to be drafted and then reviewed and approved by the board, and we will send them to you via email. If you're unhappy with the outcome of your case, you can request reconsideration within 10 days, business days, of the issuance of the resolution, and you also have the right to appeal to the circuit court within 30 days, calendar days, of the issuance of the resolution. So we haven't gone through the docket from top to bottom just to say which are postponed, which are on consent, and which are on the regular docket. So should I do that now, James? Okay, so let's just start from the top here. 2022-173 is on consent. 2022-320 is on the regular docket. 2022-324 is on consent. 2022-344 is on consent. 2022-359 is on the regular docket. 2022-360 is on consent. 2022-363 has been postponed by a request of the applicant. That will be rescheduled in January. 2022-381 is on the regular docket. 2022-389 is on consent. 2022-390 is on consent. 2022-391 is on the regular docket. 2022-393 has been postponed by a request of the applicant, and he will reach out to us when he wants to be heard again. 2022-394 is on consent. 2022-396 is on the regular docket. 2022-397 is on the regular docket. 2022-398 is on the regular docket. 2022-401 is on consent. 2022-403 is on the regular docket. 2022-407 is on consent. 2022-409 has been postponed by a request of the applicant and will be rescheduled after the applicant meets with the community. 2022-410 is on consent, and 2022-424 is on consent. Consent. Do you want to address the York Road issue?
I do. There are, which case is that here? It is
381.
381. A show of hands, folks are here for case number 2022-381. We had this matter especially set with the person who was, the other board member who was here to hear the matter. We just learned that she is ill and is not going to be able to be here. We have a party, a board member who has a conflict, so we would not have the requisite 4 members of the board for that case. Unfortunately, we just learned this while trying to reach that board member, Jay Bonner, who cannot be here and she's ill. I will leave it to Ms. Witt to work with you all to rehear the matter, but we'd be here with 3 board members to hear this case. So the board, I think, is precluded from doing that.
Yeah. So, yeah, I think that we also called the other alternate board member who's not able to come on short notice to hear the case today. So we're kind of in a position that
Yeah,
can't
it's
really do
certainly
anything about.
no fault of yours. It's the administration that needs to provide a full complement of directors. We just don't have that. So I'm sorry? I'm willing to serve. Hey, I'm happy to have your interest and follow the process, but we're sort of adjusting on the fly here. We have 2 alternates who are on standby. The 2 very busy lawyers. The one we had on standby, unfortunately, is sick, and the other one we can't get out of a meeting. So I apologize for that, and we'll do the best we can to get it back on as quickly as we can.
Can we reschedule for the following meeting?
Sure, so I'll have to confirm with Jay and Frank about who can come, but I will ask them to be there for December 6th, and I will follow up with everyone as soon as I can, today or.
We'll change the slide.
Thank you for your consideration. Appreciate it. All right, so 2022-381 necessarily is going to be postponed.
Another thing I just wanted to mention is that Mr. French is also sick today. So I'm going to be doing my Martin French impression today. So y'all can judge how good that is.
Yeah,
Really a lot of research done.
yeah, it takes a lot, obviously, to put this on, and we're shorthanded. I don't know what else to say. So thanks for your patience. Appreciate your efforts, Ms. Wade. Might start drafting from the audience. I see a couple familiar faces out there with names. Good to see you all. All right. Are you done?
I just did my whole thing,
All right.
and so you can start
I'll
with
do my
the
short
consent.
thing. So again, we have the docket split into 2 sections, the consent docket and then the regular docket. The regular docket, of course, will present matters by the appellant, and then we'll hear from opposition, and the appellant has the last word. We will endeavor to, deliberate on your matter at the conclusion of your case. That's the process we are following now, unless it appears that we need additional information or for any number of reasons that might arise, we believe we're unable to undertake deliberations. So we would ask that to the extent there are multiple participants in the opposition, that you listen carefully to whoever speaks before you in support of that opposition, so that we're not repeating those same bases of opposition. Back to the consent docket, those matters are matters for which we believe the board believes it has sufficient information to approve the appeal. So the process will be you come to the podium, we'll hear, well, all of you will be sworn in, then you show up when we call your case, line up in the order that the cases are called. We'll hear any reports from staff and also planning. I'll ask you if you have anything else you'd like to add to the record in support of your application, and then we'll dispose of your matter, which is a favorable disposal, effectively in its approval. Of course, you have to wait for the actual written ruling and so on and so forth. So that's how that will work. What are also my other admonitions? We ask that you not undertake any work on your project until you have your ruling from the board. These are the contested matters. And certainly don't undertake any work in Baltimore City without pulling the proper permits. Because that will show up if that occurs. That won't be good. Anyway, so we'll begin with the consent docket. Please line up behind the podium in the order in which your case is called, and we'll begin to hear your case. First case on the consent docket 2022-173, 1315 Harlem, Bashir Hijazi, the appellant. Case number 2022-324, 201 North Kenwood Avenue, Xu Chuan Yang. Then case number 2022-344, 3000 Temple Gate, AB Associates. Case number 2022-360, 1430 Carswell Street, Key and Powers is the appellant. Case number 2022-389, 40 East Heath, David Christian is the appellant. Case number,
Which one was that?
I'm sorry, 2022-389, address is 40 East Heath. Case number 2022-390, 109 South Schroeder, 410 Development LLC. Is the appellant there? Case number 2022-394, 900 South East Avenue, AB Associates again. Case number 2022-401, 517 South Wolf Street, Julie Tice is the appellant. Yeah, if you could just wrap the line around, whatever, wherever you fit in comfortably. Case number 2022-407, 5814 Hillen Road, BGE is the appellant. Case number 2022-410, 3922 Clover Hill Road, Eric Elton is the appellant. Case number 2022-424, 6313 Ivy Mount, Yehoshua Hochstetter. And that's the consent docket.
I didn't hear our case.
All right. What's your case number, sir?
2022-320.
Okay, my understanding is that's on the regular docket.
It is, yes.
Okay.
He's here in opposition, so.
So we're
There's
only
opposition.
calling the consent cases first? We'll get to you all. Thank you. We have all the parties sworn?
Anybody who's going to testify, please raise your right hand. I'm voting for the consent docket. Okay, do you solemnly swear or affirm under the penalties of perjury that the testimony you're going to give, the statements made, and responses given will be the truth, the whole truth, and nothing but the truth?
All right, thanks so much. Again, first case, 2022-173, 1315 Harlem, Bashir Hijazi. Good afternoon, sir.
Good afternoon.
I will, and this is a request to use the premises as 3 dwelling units?
All right.
All right. I hear from the
From me.
suspects.
Yes, so there's one variance being requested here, a minimum lot area variance, 1,875 square feet is required, 1,456 square feet exists, so it's a 419 square foot variance. I just did want to point out for the board that there was a letter from a community association saying that Mr. Hijazi had not met with them. That was back when this appeal was first scheduled in June. There's no requirement that property owners meet with the community, but that is just in the file. Let's see, okay, so the Department of Planning submitted a memorandum. The department has no objection to this application. Should the board determine that the application is approvable, the department recommends that approval of this application be subject to the condition that use of the property complies with the terms and conditions of Baltimore City Code, Article 23, which is the sanitation code.
All right. Mr. Hijazi, do you agree to compliance with Article 23 sanitation code?
Absolutely.
All righty. Is there anything else you'd like to add to your application at this
No,
time?
but basically, based on my understanding, the building was a 3 dwelling before.
There you go. It's on now.
No, so the building was a 3 dwelling before, so it was just basically because it was vacant for a while, we're trying to take it as a three dwellings.
Very well. The board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you so
sir.
much. Have a wonderful day.
You do the same. Case number 2022-324, 201 North Kenwood Avenue. Xu Chuan Yang.
Good afternoon. My name is Andrew Chu,
All right.
and I'm Shu Jen Yang's husband.
Very well.
Chew.
And sir, this is a request to use the premises as a single-family dwelling in an accessory home daycare up to 12 children for a portion of a 24-hour day. Is that correct?
Correct.
All righty. I'll hear from staff and planning.
So this is, there's 2 requests here. There's a conditional use as a daycare for up to 12 children, and an off-street parking variance, 1 space being required, 0 proposed. The applicant did provide a little bit of additional information to the board, which I requested yesterday, about how they plan to do pickup and drop off, how many staff they have, what kind of street parking there is, and that is all included in your docket memo, and exterior lighting as well. The planning department recommended approval of this application.
Okay. Sir, is there anything else you'd like to add to your application today?
None at this time. Thank you.
Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you very much for your time, and thank you very much for the questions of clarification.
Okay, good luck to you, sir.
Thank you.
Case number 2022-344, 3000 Temple Gate. Good afternoon,
Good afternoon.
Mr. Casagnola. Right?
Good to see you.
AV Associates. This matter addresses variances to bulk regulations to construct one-story rear addition to the existing detached single-family dwelling. Is that correct?
I sent updated plans. It's a 2-story addition. It doesn't interfere with the setback and appeal request.
Okay.
Let's get your name, please.
Castagnola, Castagnola.
So there are 2 variances being requested here. One is to the minimum rear yard setback, 25 feet is required, 8 feet, 10 inches proposed, so it'd be a 16-foot, 2-inch variance, and a minimum interior side yard setback, 10 feet is required, 5 feet, 8 inches is proposed, so it's a 4-foot, 4-inch variance requested. Planning Department did not have a comment on this appeal.
Okay. Ms. Witt, do you have in your records now the 2-story addition?
Yes.
Very well. Mr. Casagnola, anything else you'd like to add to your application today?
It's great. It's going to help these folks have their parents' age in place. Appreciate the board's consideration.
Okay. Board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you.
Case number 2022-360, 1430 Carswell Street. Keys and Powers, Inc.
Hi, Drew Tilden, Rosenberg, Martin, Greenberg, on behalf of the applicant.
Wonderful. This is a request to use the premises as a community center with an accessory daycare facility, and the variance is required for off-street parking. Is that correct?
That's correct.
Wonderful. Ms. Witt, from planning and staff.
All right, so this is a conditional use as a community center with an off-street parking variance. 1 space is required per 10 persons of fire-rated capacity. 0 spaces are proposed. And there are other folks here who also want to testify besides the appellant. Councilwoman Ramos is here as well. I believe there's an MOU in the file with the Chum Community Association. The property was previously used as a community center, but was vacant for more than 2 years, which means that the previous conditional use expired. And let me see if I have a planning memo to share. I don't have it offhand, but I might come back and give the conclusion for the planning memo. Hold on a second.
Ma'am, while she's looking, can I get your name?
Yeah, Drew Tilden, Tildon.
Okay. Let me just review.
Oh, wait, I have the conclusion of the planning department. It says, the planning department has no objection to this application provided that sufficient off-street parking is provided by the applicant to serve the capacity of the proposed community center.
I'm sorry, sufficient off-street parking is provided with regard to the community center portion?
Yes.
Okay.
And may I speak? So we entered into an MOU with Shepherd's Clinic for off-street parking. It's located directly behind the property, so participants won't actually have to cross the street. They can walk directly to the property. Additionally, this is a youth workforce development program. So in general, participants won't actually be driving to the center.
Okay. Great. Councilman Ramos, would you like to be heard?
Sure. Thank you, Mr. Chair, members of the committee. I am on my tiptoes, too. Odette Ramos, Councilwoman for the 14th District. I do want to thank Keys and Powers. They've been in constant contact with the community association, the Coldstream Homestead Montebello, about their plans. The only concern that the community association had was just the conditional use being removed. What they wanted to make sure is that if Keys leaves, which we've gotten the, assurance that they're not planning on going anywhere, that the condition goes away immediately and not waits that 12 months, because they don't want to have to worry about the building being empty and going through a process. So, and somebody going in there using the conditional use without, their agreement. So we've got that in the resolution that we will, they've agreed to it, and also Ms. Witt will put that in the resolution. Otherwise, we're, on behalf of the community, excited for Keys to be there, and it's a good use of the building, and we look forward to working with them, and thank you again for, negotiating the MOU. So we want to put that in the resolution as well, the filing of the MOU, and looking forward to the next steps. Thanks so much.
Thank you. Appreciate it. Okay. Anything else you'd like to add to your application at this time?
Yeah, so we actually provided the MOU already, and we also are requesting that the terms be incorporated into our application.
Absolutely. Okay. Well, with that said, the board, having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you.
Thank you so much. Good luck to you all.
Good teamwork.
Yeah, very good teamwork. Okay, case number 2022-389, 40 East Heath. David Christman is the appellant.
Yes, sir.
Is that you, sir?
Yes.
Okay. This matter addresses variances to bulk regulations to construct a two-story rear addition and rooftop deck.
Yes, sir.
Okay. We'll hear from staff and planning.
So 2 variances requested here. 1, minimum rear yard setback 20 feet is required, 9 feet 4 inches proposed, so it's a 10-foot 8-inch variance. And maximum lot coverage, 80% is allowed, 85% is proposed, so it'd be a 5% variance. The planning department did not have a comment on this application.
Okay. Mr. Christman, is there anything else you'd like to add to your application today, sir?
Nothing else to add?
Very well. Board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Okay.
Thank you.
Thank
Good luck
you.
to you. Okay. Are you with this case?
Yes.
Okay, well, we'll hear from you.
Okay. I'm the prop one. Kevin Stevens, Stevens. So I, along with my wife and 2 other partners, own the property right adjacent to number 40.
Okay.
We bought that property in June of 2021, and
Let me stop you. Are you
Yep.
here in support of this application?
I support this, yes, with a proviso, if I can speak.
Okay,
All right.
go ahead.
When we bought the property, the number 40 was undergoing construction, like massive renovation, without a permit. In July of 2021, the city came in and shut them down. On September 1st, the remnants of Hurricane Ida came in and flooded our house because of that damage that they did at number 40. So it's great that they're applying through the proper process. What we would like to do is ask if they can make sure that they also repair the drainage and the seam between the 2 properties. We've put in over $30,000 in repairs to our property because of the work that was done, not by them, but the previous owners.
Let me back up. That doesn't sound like a consent issue with a request that a party expend money in exchange for your support for the project. So I'm wondering why this is on consent.
Oh, I think I may have missed his, did you sign in support or opposition?
Well, I signed in support.
Okay, that's
Yeah.
why, because there wasn't any opposition on.
Okay.
So if they make these repairs and they do this build out and everything that they want to do, they also have to waterproof the property.
Well,
That would be helpful, so we don't
Would be,
go around in circles.
that's not before us.
Okay,
So what is before us is the variance to the bulk regulations to construct this. There are apparently some residual issues that give rise to this issue or concern.
Right.
Have you spoken with the appellant?
Met them first time. They're very open to talking with us.
So
I
how about
want to,
this?
I just want to vote yes, go forward, but get it under
Well,
proper.
I guess here's the question.
Yeah,
If we can't resolve this, or if you don't get a satisfactory answer to your questions or your discussions with them, does that change your support of this project? Because what we've just done, what we're seeking to do is to grant approval
right,
to them going forward.
Right.
Without any of the conditions that you're raising. Because
right.
again, that's not before us.
Yeah.
So I guess what I would say is I could encourage you to, again, communicate with those folks. Sound like you're off to a good start. And see what issues you guys can reach accommodation on. Because if it doesn't address the variance for which they're here, why they're here, then it's not before this particular board.
well, the variance is calling for like a roof deck and things like that, but, you know, it didn't say anything about making sure they're up to code on drainage and everything. All that's gone on that property. That has to be built. So if you approve like a deck or roof or an addition in the back and that kind of thing, you have to have drainage. And all the flashing is gone, downspouts, nothing's there. And water washes into our property, so.
Yeah, it sounds like building code issues, things that need to pass other inspections
Okay.
in order to fly. But with regard to the zoning issue, again, it's for what we're deciding and what we had before us.
Okay,
That's not before us. But
All right.
I would encourage you to continue to speak with those folks. I think you'll
will
probably.
do, but thank you for your time.
Well, thank you, sir.
Yes, sir.
Okay. Come on back up, Mr. Chrisman. I just want to be sure the record's clear. This is on the consent docket. The board has found sufficient information to approve your appeal.
Correct.
And so I'll say again for the record, because I didn't want that to be the last word,
Right.
that the board had sufficient information to approve your appeal. So that disposes of this particular matter for us.
I understand.
And good luck.
Thank you, sir.
Thank you. Yeah, all these folks have been sworn.
I'm framed right now.
Sorry. Case number 2022-390, 109 South Schroeder. 410 Development LLC is the appellant, and you, sir, are?
Chike Owanabe. First name is Chike. Last name O, N as in Nancy, W, U-A, N-A, I, B as in boy, E.
Okay. And, sir, this matter addresses variance to bulk regulations to demo and rebuild the existing second floor addition?
Yes.
Okay. All right, I'll hear from staff and planning.
2 variances are needed. Minimum rear yard setback, 20 feet is required, 3 feet is proposed, so it'd be a 17-foot variance, and maximum lot coverage, 80% is allowed, 94% is proposed, so it'd be a 14% variance. Planning did have a comment. They said they wrote their memo, and at the end it said the Department of Planning has no objection to this application, so. That's it for me.
Bear with me one second. Sure. It's a note that I had here. Anyway. Anything you'd like to add to your application today?
No.
And with regard to Mr. French's comment, is there anything else we need from this gentleman?
No, it says the planning department has no objection to the application, so.
All right. The board having heard your appeal, we believe you have sufficient information to approve your appeal. Thank you, sir. Case number 2022-394, 900 South East Avenue. AB Associates, Mr. Berry, welcome. This matter addresses variance to bulk regulations to alter the interior for 8 additional dwelling units. It's like 4 dwelling units on the first floor, 4 dwelling units on the second floor, for a total of 46 dwelling units. Variance is required for off-street parking. Is that correct?
Yes. Just a quick history of this. The previous board in 2016 approved.
Hang on one second. Let me just get the reports and then you can.
Okay.
So
Staff and planning?
there's 2 variances being requested here. One is for minimum lot area, 3,600 square feet is required for that many units. 36,000, I don't know, I think I said 3,600. 36,000 square feet is required. 24,600 square feet exists, so it'd be 8,400 square foot variance. And then off-street parking, 8 spaces are required to add 8 units, 0 are proposed, so it would be an 8-space variance requested. Planning recommended that approval of this application be subject to the condition that secured assigned bicycle parking is provided to serve the proposed additional dwelling units.
Mr. Berry?
Okay.
Could you speak to those planning?
The planning conditions are fine. This is the former St. Bridget's School in Highlandtown. The board approved a conversion of that in 2016. There are, at the time, because it was a historic property under the National Park Service for tax credits, the gymnasium, some of you maybe played there when you were growing up, was required to be maintained as an open space gymnasium. That requirement goes away after 7 years, and so consequently, the developer wants to fill in this vacant space with 2 floors of 8 units total. We have an agreement with the Canton Community Association where the new 8 units will be given parking on the existing parking lot as part of their lease. We now have over half the parking spaces that are available to tenants not being used. So we have those spaces, and we appreciate the board's approval today.
Okay.
How could you say your name on the record?
Yeah, Al Barry?
The bicycle parking, is
Yes.
that going to be provided?
Yeah, we have, yes, we have storage rooms, and we can provide the additional parking spaces for the 8 units.
Okay, very well. The board having heard your appeal, we believe we have sufficient information to approve your appeal.
Great,
Thank
thank
you,
you.
Mr. Berry. Case number 2022-407.
401?
Ah, you're right, I skipped 401. Let's do that. 2022-401, 517 South Wolf.
Please don't break my heart.
That's all right. Ms. Tice?
Yes.
All right, this matter addresses variance to bulk regulations to construct a second-floor addition to the existing detached accessory structure in the rear. Is that correct?
Correct.
All right. We'll hear from staff and planning.
Okay, 3 variances are requested. Accessory structure, maximum height 15 feet is allowed, 28 feet is proposed, so it'd be a 13-foot variance. Rear yard setback, 25 feet is required, 0 is proposed, so it'd be a full 25-foot variance. And interior side yard setback, 15 feet required, 0 proposed, so it'd be a 15-foot variance requested. Planning department does not have a comment on this application.
Okay. Ms. Tice, is there anything you'd like to add to your application today, ma'am?
No.
Very well. The board having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you very much.
Thank you. Good luck to you.
That's how you say your name for the record, since you didn't get it on there.
Julie Tice.
Thank you.
Now, case number 2022-407. 5814 Hillen Road.
Yes.
And BGE is the appellant, and you are?
Jennifer Bussey with the law firm Whiteford, Taylor, and Preston.
Okay.
B like boy, U, S like school, S like school, E.
All right. And this is a request to use the property as the electric substation, outdoor with accessory telecommunication facility with variance for a perimeter wall. Is that correct?
Correct, thank you.
All righty. And what do we have from staff and planning?
Okay, so we have 2 conditional uses and 2 variances, as far as I know. Ms. Bessie can correct me. So the conditional uses are for electric substation, outdoor, and telecommunications facility. And then 2 variances to maximum wall height, 3.5 feet is allowed, 12 feet is proposed, and minimum rear yard setback, 20 feet is required, 0 is proposed, and that is for that exterior perimeter wall. That's it.
Okay,
Oh, yeah, planning did not have a comment on this application.
all right. Ma'am, is there anything you'd like to add to your application today?
Yes, I appreciate, first of all, thank you for your time today, and we're really appreciative of the time of Ms. Witt and the neighborhood. There was a lot of energy and patience and time from the community to arrive at the best end product. To comment on the application, on the variance, what we did just to be safe is in the event that the proposed wall, which will screen the infrastructure, in the event that was considered more than just a fence or a wall, we went ahead and asked for the setback approval as well. With regard to the height, the goal, of course, is, as was stated, 12 feet. Because of the grading of the property, in order to have it step down, there will be some spots where it is greater than 12, which is why we asked for the variance to be actually 12 to 16 at the most. But again, it's basically a 12-foot wall, just where it steps down, it will be slightly taller.
All right, very well. The board, having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you very much.
Thank you. All right. Okay. Case number 2022-410, 3922 Clover Hill Road.
Yes,
Eric Elton.
that is me.
Mr. Elton?
Yes.
All right, welcome. This matter addresses variance to bulk regulations to construct a 2-story rear addition.
Correct.
Correct? All right, I hear from staff and planning.
So 2 variances are required here. A maximum lot coverage variance, 35% is allowed, 37% is proposed to be a 2% variance, and minimum rear yard setback, 25 feet required, 11 feet 6 inches proposed, so it'd be a 13-foot 6-inch variance requested, and Planning Department did not have a comment on this appeal.
Okay. Mr. Elton, is there anything you'd like to add to your application today, sir?
Not at this moment, thank you.
All right. Board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Great, thank you
Thanks
so
so
much
much.
for your time.
Good luck to you. Last consent case, case number 2022-424, 6313 Ivy Mountain Road. Mr. Hochstetter?
Yes.
How are you, sir?
Good, how are you?
Good, thanks. This matter addresses the variance to bulk regulations to add a second floor to the existing house and remodel the first floor, keeping the same setback on the second floor on the interior side yard. Is that
Yes.
correct? We'll hear from staff and planning.
So 1 variance, the minimum interior side yard setback, 20 feet is required, 3 is proposed, so it's a 17-foot variance requested. And as you said, this is a request to add a second floor to the existing first floor. The building is not getting any closer to the lot line. It's not, it's just going up, basically, from the existing footprint, adding a second floor. And planning did not have a comment on this appeal.
All right. Mr. Hochstetter, is there anything you'd like to add to your application today, sir?
No, sir.
All right. Board, having heard your appeal, we believe we have sufficient information to approve your appeal.
Thank you.
Thank you.
Thank you so much.
All right, good luck to you. Okay, we're going to turn our attention to the regular docket. And we'll get started with case number 2022-320, 1700 North Payson Street. Omar Yahya Al-Gadari.
I'm not him, but I'm here.
You're here for this case?
I'm here in opposition.
Understood. 1700 North Payson, to use the ground floor as a carry-out food shop. Anyone here on behalf of 1700 North Payson? He may have.
So I did reach out to this person because this conditional use cannot be granted in this zoning district. And they did respond to me. I asked if they wanted to postpone, and they didn't quite answer, but they seemed to say no, that they were going to go ahead. So it could be that there was some kind of misunderstanding between me and the applicant, but in any event, this appeal can't be granted because it's a R7 zoning district, and they're requesting a carryout use, which is just not permitted. A restaurant use is permitted, but a carryout is not. And I tried to kind of explain that to them via email.
Okay, so should I be calling the case and disposing of it, or?
I think we can, especially if the
Yeah.
opposition is here.
Well, let's do that. Come on up, folks, or to the podium if you don't mind. So I've called the case 2022-320, 1700 North Payson. I've asked for Omar Yahya Al-Qadari, who is the appellant. The request of this application is to use the ground floor as a carry-out food shop. Mr. Al-Qadari does not appear to be here. If you wish to be heard, we'll hear from you. If you could state your name for the record. Wait a minute. You got to be sworn.
Just one second, gentleman in the back, if I can hear you all the way up here, that means my poor court reporter is getting you. Not to be the teacher in the classroom, but yeah, thank you.
Thanks, teacher.
You're welcome.
Hang on one second. He's going to swear you off.
My name is Vernon
Hold on.
Ross. And also,
Could I ask that you raise your right hand?
And anybody else who will be sworn, I mean, who will testify.
Anyone who wishes to testify, do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give, the statements made, and the responses given will be the truth, the whole truth, and nothing but the truth?
yes,
All right.
And that's Vernon Ross, ROSS?
correct.
I'll hear from you, sir.
Yes, I'm here, and I don't know this other gentleman's name, but,
I'm representing Paul Negative Fryhouse.
okay. And this is Mrs. Jennifer Convar, who is a resident in the 1600 block. I reside in the 1700 block of North Payson. And it was our understanding that the applicant, who owns a food grocery store at 1739 North Payson Street, already owns the property. He bought this new property, 1700, with the intentions of making it a carryout. And the neighborhood is very much against it. We've had a lot of crime on the corner, and I have a list of other reasons as to why. I don't know how specific you guys want us to be. I have a letter from our resident associate director, who also is in opposition, and I have 100 signatures of residents that we canvassed over the weekend of people that live in the 1600 block, 1700 block of Appleton and Payson Streets, which are immediate surrounding areas.
Okay, well, this is what I'd like you to do. If that petition has not been submitted as part of the record, you could hand it up and we can make that a part of the record, but to be sure it stays with the file.
Okay, and I apologize, this is my first time.
That's
I had
okay.
no
Well, you picked a good one, because you know what?
You're doing well so far. You're doing well.
And if it's okay with you,
This is what we want neighbors to see when they sign.
go ahead back to the podium, sir. You've indicated the basis of your opposition, and you've indicated you got umpteen other reasons for that opposition. I can tell you that this will not be approved. The applicant's request will not be approved because it's in an R7 district, and there's a prohibition on a carry-out food shop in an R7 district. So as a matter of law, effectively, that application is going to have to be denied. But I did want to give you an opportunity to at least be
Thank
here
you.
and submit whatever you have for the record. So
Thank you.
for all intents and purposes, this will be a no from the board, because we don't have the authority to grant that, and the law doesn't allow this application to be approved.
Thank you,
All right.
thank you.
Thank you, sir.
All right.
And I don't mean to deprive you all of the opportunity,
No, it's not
but
a problem.
I think the record is
We're
clear
in-
enough.
We're in agreement.
We're in agreement.
All right.
All right.
Thank you so much.
Thank you.
Waving, I'm shaking.
Well, wonderful. Enjoy your holiday, folks.
Thank you.
All right, just for the record, can you all vote on that, please?
Yeah, I'm a no.
I'm a no.
No.
Okay, that's a unanimous no. Thank you.
Okay, moving on, case number 2022-359, 707 through 709, Druid Park Lake Drive, AB Associates. The appellant, this is a request to use the premises as 11 dwelling units. The variance is required for off-street parking.
Could I beg some indulgence? The developer is in security. He'll be up here in a few minutes if you want to take another case.
No worries.
And
Very
then
well.
we thought we could, with your approval, consider both of these properties together. There's a later one, it's
Got
next
it.
door.
And which other
by
one
the
is that,
same-
Mr.?
701 and 707 are two. Essentially, they're two different properties, so they have to vote on them separately, but they're basically the same developer, same
And
project.
Is the opposition for this, is there opposition for both?
I don't know.
Okay, well, they're here. All right. Okay, we'll defer
He'll be here.
for the time being.
What is insecurity?
He's downstairs in security.
Security downstairs.
So that you can answer.
One in every crowd. Okay, we'll go ahead and call, what's the next case here? Okay, that would be the series of Highland, was that
Yeah.
Highland Avenue cases? Tell you what. All right, well, we'll get on with those then. It's the new fire alarm for the city. Ms. Witt, so should I call all of these cases together?
Well, for the
Or
Highland
are they
Avenue cases,
different issues?
there's 3 that are all the same appellant, and then there's 1 that's not the same as the other 3. So you might need to call them separately, but they all are pretty similar, and there's 1 letter of opposition that applies to all of them.
Can we call them all together? Even if I'll call them one by one, even if it's not the same.
Yeah, so let's do this. Let's, 1, 2, 3, 4.
There are 4 of them total, right?
Yes.
Yeah.
They are the 4 next cases as well, right? Yeah.
Well, we have a different appellant for one of them, 2022-391, 1210 South Highland Avenue. Brian Chance.
So, I was actually gonna stand in for him, he's the owner, but he's also involved in East Highland, so Brian Chance is not here.
You have to come up to the mic.
So they're all the same guy.
Yes, Adam Carvalho is associated with all the others.
Hi, Joshua Nicodemus, Nicodemus.
All right.
Yeah, I was hired by the owner, Brian Chance, to appear today.
Okay, for 1210 South Highland.
Yes, he's also involved in the other projects.
Understood.
He's here to represent that. It's definitely a better idea if we just group all this together. I
It's
believe.
clear you all have been discussing this,
Yeah,
so,
yeah,
yeah.
Sorry. Okay, is there opposition for 1210 South Highland?
Oh, I'm sorry.
Okay.
I didn't register, but I am in opposition.
Okay, and there are a number of people behind you that are also in opposition, apparently.
Oh.
So,
Can you see if there's opposition for the other 3 as well? Is it if the same people raise
I
their hands?
guess, are you also here in opposition for the other properties as well?
Yeah.
All right. I tell you what, why don't you all come up, let's get you all sworn.
This one can just sign
He needs to sign.
Yeah, and sir, could you sign in?
Yeah. Not do it now. It's 7. Oh, Highland.
And just for the record, the cases that I'm seeking to call are case numbers 2022-391, 1210 South Highland. Case number 2022-396, 1216 South Highland Avenue. Case number 2022-397, 1214 South Highland Avenue. And case number 2022-398, 1212 South Highland Avenue. Okay? Let's get these, and sir, with regard to any of these Highland Avenue properties, are you here in opposition? No. Thank you. If we could get all these folks sworn in.
He's gonna swear in as well, though, for the one case, correct?
Well, we're not on that case.
Oh. Yeah, we're waiting.
He stood up for the wrong number.
I got you.
Uh-huh.
So I've got 4 cases that were called.
Yes.
Correct.
Would anybody who's gonna testify on these matters, please raise your right hand. Do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give, the statements made, and responses given will be the truth, the whole truth, and nothing but the truth?
Okay, let's see. So, case number 2022-391, 1210 South Highland Avenue, Mr. Chance. This matter addresses variance to bulk regulations and expand the structure to construct additions at first and fourth floor rear, decks at the second and fourth floor rear, and a rooftop deck. Is that correct?
Yes, that's correct, yeah.
All right.
Did you state your name for the record?
Yeah, Joshua Nicodemus,
Okay.
yeah.
All right, and could read off all these others, but I think maybe when we call, I've called all these cases, so all right.
Do you want to just make a note on the record that
Yeah.
when you refer to one, you're referring to all four?
Yeah, now, that some of them have differing specific construction that's involved, but Mr. Carballo, come on up. 2022-396, 1216 South Highland Avenue. We're seeking a variance to bulk height regulations to construct a fourth floor addition or doghouse building height of 42 feet. Is that correct?
That is correct.
All right.
Can I have you state your name, please?
Adam Carballo?
Thank you.
For 2022, we probably got different issues for each one of these. All right, hold on, because I got to make this record right. So, because we have different comments with regard to the different properties, let's do it in order. 1210 South Highland Avenue. Reports from staff and planning.
Okay, so for 1210 South Island Avenue, 2022-391, there are two variances and one conditional use being requested. The maximum height is by conditional use, 44 feet is being proposed, so that is 9 feet above the 35 feet that's allowed by right, so it'd be a 9-foot conditional use as to maximum height. Then there is a minimum rear yard setback variance, 20 feet required, 16 feet, 10 inches are proposed, so it'd be a 3-foot, 2-inch variance. And maximum lot coverage variance, 60% is allowed, 81% proposed, so it'd be a 21% variance. Those are the 3 requests before the board for 1210 South Highland Avenue. Planning does not have a comment on any of these.
Any of the 4?
Any of the 4.
Okay.
Do you want me to do the request for 1216 South Highland, which you also?
Why don't we just do it? You go ahead and read them.
Okay.
We're good.
So for 2022-396, 1216 South Island, it's a maximum building height conditional use. 35 feet is allowed, 42 feet is proposed, so it'd be a 7-foot conditional use as to height. But that's the only thing that's being requested there. 2022-397, 1214 South Highland. This is to construct a rooftop deck and detached rear garage. So it's the same or a similar request, maximum height, conditional use, 35 feet is allowed, 38 feet, 1 inch is proposed, so it'd be a 3-foot, 1-inch conditional use requested. Maximum lot coverage, in this case, because of the detached rear garage, 60% is allowed by right, 100% is proposed, so it'd be a 40% variance requested. And rear yard setback, in this case, 25 feet required, 0 feet proposed, so a 25-foot variance. And the last one, I think is identical to the one I just did. So 2022-398, 1212 South Highland Avenue, to construct a rooftop deck and detached rear garage, maximum height, 35 feet allowed, 38 feet, 1 inch proposed, 3-foot, 1-inch conditional use. Maximum lot coverage, they're asking for 100%, so 40% variance. And rear yard setback, they are asking for the full setback, so 25 feet variance requested. And like I said, planning has no comment on any of the 4.
Okay, God bless you. Mr. Carvalho, go ahead, sir.
Thank you. To sort of set the table and provide some context to what is happening.
Yeah.
These 4 properties are located on the 1200 block in South Highland Avenue. That is the block in between Elliott Street and Toon Street on the west side of the block. These homes in this block suffered a fire loss earlier this year. Extensive damage that started in one of the properties, spread to adjoining properties. I believe there was 5 properties in all that were received substantial damage. Of the 4 that are here before you, I'm working on 3 of them. Mr. Nicodemus is working on the 4th one. To further complicate matters, 3 of these properties were not abandoned, but sold by the homeowner occupants to Brian Chance, who is not here. Brian Chance and I are working on 2 of the buildings, and Brian is also working with Mr. Nicodemus on the 3rd one. So there's a lot of overlap. However, I'd like to sort of present them, all 4 of them collectively, because they have similar requests.
Very well.
As I mentioned, starting at the top of the hill, 1210, that's the property that Josh Nicodemus is working on. That request is for a 9-foot special exception. In an R3, you are allowed up to 35 feet as a matter of right, 45 feet with a special exception if you are a property that's located mid-block and you have there's a right-of-way of 30 feet to the property, to the street in front of you. The right-of-way is not just the width of the street, it is measured from building to building. So that 30 feet, all 4 of these properties meet the minimum requirements for special exception as a matter of right, given that right-of-way dimension and also the fact that all 4 of these are less than the requested 45 feet. It's in the zoning code, you are allowed to do it, given those site conditions. Further, with 1210, they are asking for a variance to lot coverage of total with 81% in lieu of the 60-foot requirement. If you look at this block of 1200, not only the 1200 block of South Highland, but also at the corner of Elliott and Highland, across the street at Brewers Green Way, a lot of the properties exceed 60% coverage. A lot of them are over. In this particular case, there is a request, 1210 is requesting a garage, correct?
Yeah.
So obviously with the garage, there is a vehicular alley off that parallels Highland Avenue. Many of the residents, this is actually Wise Court, if I can read it. Wise Court is actually the vehicular traveled thoroughfare that runs parallel to Highland that provides off-street parking to the buildings on Highland. There is a extensive what's the word I'm looking for, precedent for off-street parking pads. There's a handful of garages off of Wise Court. This property in particular is requesting a garage, which then in turn increases the lot coverage. This particular property, the garage is only on the first floor. It's not a 3 or 4 story garage by any means. Moving down the hill, 1212 and 1214.
Just to make sure there's an existing fourth floor already there.
And as Josh, correct me, there is actually an existing 4th floor penthouse at this property. So it's continuing an existing condition that already is enjoyed at this property, 1210. 1212 and 1214 are meant to be sister buildings. They're identical in design. These do have a third floor, excuse me. There's a lot of buildings, so I'm trying to get myself straight here. It does have a 4th floor penthouse, as well as roof deck, and a rear garage as well. Given the existing conditions and the existing ceiling heights, we're only asking for an increase to 38 feet in lieu of the allowed 35. We certainly do meet the requirements to allow up to 45 feet, given the right-of-way condition that's in front of the building. But we are showing some constraint by not asking all the way to 45 feet. We can, we're only asking for three additional feet to that special exception. And that is the same request for 1212 and 1214 South Highland. Finally, 1216, this is for the owner-occupant. This is a family who lost their home to a fire. They wish to stay. They're one of the only families that is choosing to rebuild and stay in the neighborhood. They had an existing 3-story home with a roof deck. They are not proposing a garage. They're not proposing an increase to their lot coverage, but they do want to increase renovate the 3rd floor and then add a penthouse that would give them access to their roof deck. Again, with this height would be up to 42 feet in height in lieu of the allowed 45 with a special exception. I will note that All four of these, or at least all three of these properties, the ones that I was managing, did present to the Canton Community Association on September 12th. We presented this to the group. I wrote into my office to see if we received a letter of support, but we did meet the minimum requirements to present this project publicly at that forum.
Okay. Was there a collective response from the Canton Community Association?
To be honest with you, I don't remember. I don't believe that we received overwhelmingly negative response. I'm sure that that would have continued the conversation.
Right. And Ms. Witt, there's no letter in the file from opposing support?
I don't believe we got a letter of support, but I think it was possibly neutral. Maybe we heard positive and negative comments at the meeting, but we did meet with them, which is what the requirement is.
Got it.
There's nothing from the community association in the file.
Okay. All right. That concludes your initial.
Yes, sir.
Okay.
Unless there's any questions.
The special exception you're referencing. I wonder if you could explain or talk about that just a little bit more.
Certainly.
Under the code, the special exception allows what in relation to this particular project that you're?
So in an R4 zoning, or excuse me, an R8 zoning district, you are allowed 35 feet as a matter of right. The zoning code further states that for a property that is mid-block that enjoys a right-of-way of 30 feet or greater to the roadway that's immediately in front of the property, you are allowed up to 45 feet with a special exception. The only two requirements are mid-block building and 30 feet of right-of-way and presenting in front of the board. If you meet those two criteria, you are allowed up to 45 feet. And there are dozens of precedents for this. I've probably personally brought at least a dozen of them in front of this board over the last 10 years that have been granted for that height enjoyment. It's purposely written into the code to allow for 45 feet for roadways and right-of-way that are wider roads. Obviously, on a narrow road, 15 or 25 foot right-of-way, the code specifically restricts those. But on a major right-of-way such as Highland Avenue, the code is written to support the increase in height and on those properties in those areas.
Okay. For the record, the director can.
Can you put the microphone on, please?
For the record, the director can confirm that?
Yes, that's true. In Baltimore City, we call special exceptions conditional uses.
Just wanted for the record.
Yes, that is true. So that's why I said when I was introducing it, that those heights are by conditional use rather than by variance.
And I will say, with all four of these cases, we are not extending all the way up to the allowable 45 feet. In two of these cases, we're only asking for 38, which is just a mere 3 feet higher than what we're allowed to do as a matter of right. We certainly could have pushed the envelope and gone up to 45 feet. However, there has been a level of constraint, self-imposed constraint to limit the height. And as you travel south on Highland Avenue, you're actually going downhill. So properties that are to the north of Highland Avenue, by nature, are already going to be higher than this property.
Okay. All right. Any questions for Mr. Carballo at this point? Okay. Mr. Carballo, thank you.
All right, thank you.
We'll hear from the opposition. State your name and we'll hear from you.
My name is Melinda, last name Maluga, Maluga, and I live at 1125 South Highland, which is directly kitty corner from 1210 South Highland. I actually have some pictures I'd like to share with you, if that's possible.
Are these photos that we can keep?
They are.
Okay, wonderful. Just go ahead and hand them up.
Don't have one for everybody.
That's okay. Yep. Thank you.
In 2005, I moved to Baltimore, bought a beautiful home at 1125 South Highland. Wonderful water views. It was sold as water views. And a beautiful picture of Fort McHenry. It's priceless. It absolutely is priceless to us. I walked up to our roof deck, I guess maybe 8 days ago, and saw the structure on 1210, which totally takes away our right side of the water view, only to find out that the other 3 houses will take away the other side of the view, and we will no longer have any water view at all. There's a value to water view. You can talk to the apartments, which are a block away. They charge more for water view. There's a value there. And if those houses get renovated with the 4th floor addition and a penthouse on the top, that will seriously hurt the value of our homes, of all these people that came here today. Because those units on Highland, on the 1100 block of Highland, are a conformed development. So we all step down toward the water. We all have a wonderful view. We all bought our homes the same year. And this will totally take it away, as you can see from the pictures. Because it actually goes to, 1210 actually goes to a 5th level. There's a 4th floor addition, and then on top of that, they're putting another deck. So there's nothing in the area that is 5 levels that is a residential home. There were homes built on Brewers Green, which is a street that comes off of South Highland that they renovated several years back, which was actually commercial. And that's why they were allowed to do that. This is the highest, 1210 is the highest residential building on that block and probably for 2 or 3 blocks around it already, currently, as it was before the fire.
Well, let me raise an issue with you, and actually, we direct it to Ms. Witt first. With regard to the concept of water views in a given property, what does the code say regarding the right to a water view, if anything?
So I would direct you all in terms of deciding whether or not this height should be approved. I would direct you to the conditional use standards, which I can pull up here. I think might have them. Bill, do you have the conditional use standards in front of you? Do you have the conditional use standards that, let me just, if you want to take a look at those tend to, so again, the conditional uses are presumed to be valid unless the board finds that they are in that specific location are going to be unusually harmful, basically, to the public health and safety. That is under the Schultz versus Pritz case. And if you want to take a look at the conditional use standards, I think Bill could pass that down to you. But so the code doesn't directly address water views. You would just have to apply the conditional use standards to this appeal.
Now, with regard to conditional use, with regard to height, in the face of this special exception that we've been discussing, does the special exception take precedence over? Special exception provides a circumstance that one can have as of right if the conditions are met.
So special exception is just another term for conditional use. So in the city, we call them conditional uses. In other counties, or in other states, they call them special exceptions.
Okay.
So you would apply the same conditional use standards that you would apply to any other conditional use. It's just hard to apply them to a dimension instead of a use because they were intended to be applied to uses and not heights, but that's not for us to, we're not legislators, so.
Is what it is. Ma'am, let me ask you a question regarding and I've heard your testimony regarding there's a value, and you've given the analogy of the apartments charging higher rents for water views. Have you been able to quantify by any means, by use of an appraiser or a real estate professional, what you believe to be the diminution in value would be to your home?
I've reached out to people. I haven't gotten an answer back on that. I think it takes some time to figure out, how old the house is and all the varying factors that go in that. But we're probably soon going to know because somebody here in the group will be selling their home in the near future. And it will be impacted. And that's a sad way to find out.
All right. Anything else?
No.
All right. Thank you, ma'am.
Thank you.
Hello, everybody. My name is Mike Boquard, Boquard. I just want to say that I agree with everything Melinda Maluga has just testified against. Those buildings are too high. They're already built. The thing that kills me is they're already built. They haven't gotten the variance yet. That section of Highland Avenue is flat. It's not on a hill. So it affects all those neighbors in the 1,000 block, the 1,100 block where I live in the 1,200 block. The houses there are all 2 stories and 3 stories. Some of them have a rooftop deck, some of them don't. None of them are 4 stories, and none of them have a 5th floor rooftop deck. You put a 5th floor rooftop deck in, you put umbrellas, you put picnic tables, you put gazebos, and now they have 5 floors. They're just way too high for the neighborhood. It affects my view, and it affects the value of the house, not just the view, the value of the house and that whole stretch of neighborhood. So
I'm sorry, you said it affects not only the view, but the what? The what of the house?
The value of the house.
The value, okay.
Yeah. So the developer talked about Brewer's Green. They have taller houses, but that's not on Highland. That's perpendicular to Highland, and that was zoned differently because there was an old warehouse there that burnt down years ago, and they built that construction. So that is not on Highland yet. So anyways, to cut to the chase, I disagree with allowing this variance. Thank you.
Thank you, sir.
Hi, good afternoon.
Good afternoon, ma'am.
My name is Cheryl Lerner, Lerner, 1119 South Highland Avenue, a couple doors down from Melinda. I purchased my property in 2018, specifically because it was where it was located and it had a beautiful water view on the roof deck. It's one of the homes that were built in 2005 to emulate the historic homes in the neighborhood. So they do fit in nicely, and they provide great views, but also an excellent location. It brings a lot of value to our area. One of the things I really like about the Canton area is that it's gentrified in a good way, and it's preserved a lot of the people who've lived there for a while, as well as newcomers. And it's pleasant to live there and to live near the water. It's very critical, that piece of the water. The historic value of seeing Fort McHenry, of being able to see the Domino Sugar Factory, of being able to see Silo Point, all of that stuff is very impactful to the cost of a house and for the sale of a house. And I'm the one planning to be retiring in the relatively near future, and this absolutely impacts. It will be a huge loss from having lived here only 4 to 5 years. I took pictures today from my rooftop, but they're pretty similar to what you see with Melinda's, because I'm just a couple houses down, and we will obscure the already partially obscured view that we have today. It sounds maybe a little petty because it's a view and the use doesn't impact the health or safety of anybody, but it really does make a huge difference to the entire neighborhood, who we all work together, we all play together, we all spend time together, and we're all disgruntled about this variance. So in short, I'm also against it. Thank you. Do you have any questions?
Thank you. No, ma'am.
Okay.
She just acknowledged it.
Good afternoon, everyone. My name is Tracy Halliday, Halliday.
Michael Palmer, Palmer.
Sorry, I didn't see you there. We live at 3301 Elliott Street, so we are not on the Highland Avenue side. We are diagonally across the alley from the houses that are being redeveloped. We agree with all of the comments previously made in opposition to the granting these variances. Two additional things I just would like to add for the record. One, we were all there when we watched these fires go up. They went up really fast. They went up to the roof and across the roof and took all these homes out. We were packing up our animals. We were getting ready to evacuate ourselves. We watched the firefighters come in droves and risk their lives to save the people in the homes, to save the homes themselves. Building up only creates more of a risk for those in the neighborhood, for those in those residences, for firefighters of the city. And that's a real problem and something we should be thinking about as we build up in the city. Because if you grant these variances, what we'll start to see, and are already starting to see, is the ripple effect that's happening. You grant a variance here, someone asks for one there. Next thing you know, the quaint neighborhood of row homes with water views become high rises, like we're already seeing happening in Brewers Hill. Or they become 5- and 6-story homes. And our home right now, the view will not be blocked. We look across South Clinton over the soccer field. 2-3 years from now, that could be a completely different story as we see development happening out of Clinton. So I just ask you to consider that as you think about the impact beyond what you do with your decision today.
Thank you so much.
Thank you.
One thing I'd like to add, the fact that we lost almost an entire block and the planning board has no comment on the reconstruction of this block is pretty appalling. And this is taking away almost an entire street, except for 2 homes. 2 homes is the only 2 that did get lost on that entire street. And our home is about 50 feet from where this fire started. And in the course of 15 minutes, all of them were on fire. Because where it started, it's a recent build out in 2016. They had all the fire wrap on the walls. It was contained. Where it spread was the 2 houses adjacent that had extended beyond their normal variance that had no fire wrap. So that's where all that fire went to the roof. Unfortunately, I think that week we'd had heavy winds all week long. That morning, strangely, there was none. By the time the fire hit its peak, 12:10, the fire was about 30 feet above the building, ready to jump the back alley to our neighbor's house, who they weren't home at the time. Our closest neighbor, who now have moved, they went to another state because they were fearful. That's who woke us up at 4:30 in the morning with her screaming with her infant. And her house was 10 feet from where these fires were. We do fortunately have a wide street on Highland and the alleyway, Wise Court. If not, the firemen wouldn't have been able to make it down there on the first response that started to get under control. And I think it was starting to jump to the houses on Clinton because of all the garbage and low new construction where they've added garages going out to the edge of the alley. So what you're doing is adding a lot more fuel to a strained neighborhood where we had 26 apparatus in our surrounding block from the fire company. 2 ladder trucks, one which took about 30 minutes to navigate through telephone wires over higher properties in order to get on top of the fire. So when you start adding this height and extending out to the alley, you're putting the rest of the homes in danger. So I would just please consider we have these regulations in place for lots of reasons. And I understand and I completely respect the builder rebuilding the neighborhood, trying to make the best return on his investment. I just ask that we stay consistent with the neighborhood. Thank you.
Thank you so much.
All right, my name is Mike Matlos, Matlowsz, and I live in the shadow of the home that's currently under construction at 1210 that I believe has been extended in advance of this hearing. Construction's already underway, and it too is blocking our review, but my primary concern is over the safety and the density of what is now being built.
I'm sorry, what's your address?
3311 Elliott. So the back of my property across an alley meets with 1210. I guess a question, what is the definition of a mid-block home? In the special exception that was referenced, I picture a home in the middle of a block. 1210 Highland is the last home in that stretch of Highland. So I wonder if that even qualifies for a special exception, because it's an end unit in that block. It's just a question I'll put forth. The other thing I want to challenge that was said earlier, it was said that as you go up the hill on the 1200 block of Highland, which I agree is flat, that the homes step up. I'm again the next home north of 1210, and we're only 3 stories tall. Apparently when those homes were being built, the neighborhood challenged the 4th floor that was proposed, and the board struck it down to provide or to protect the sanctity and the character of the neighborhood. And that's what I fear that we're now going to lose if we continue to allow the extension of homes to 4 or 5 stories. It's something that was fought before and won, and now I feel like we're going to lose it. And again, the ripple effect will continue to take place. The homes across Highland that were referenced that run perpendicular, different zoning, and they step up towards an apartment building that sits much higher as you move east in Canton. But this is moving west towards more of a residential area, and it just feels and appears to be very out of character with the rest of the homes that are built there.
All right, thank you, sir. Any questions? All right, thank you. Ms. Corbella.
Thank you. In response to the comments received, as is standard in all zoning cases, and not just in Baltimore but elsewhere, there is no right to a view, especially a view. Most of the testimony is coming from the 1100 block of South Highland Avenue. This block is approximately 4 or 5 blocks from the water. By this precedent, you're more or less stating that no one can build anything between their property and the water in order to preserve a view. No one has a right to a view. A view is important, a view is nice, but it's not a right. And it would be unreasonable to say that everyone between that property and the water can't build, can't improve their property, can't build in accordance with the zoning code. It would be an unreasonable request. Where does it stop? Does it stop at 4 or 5 blocks away from the water? Does it stop at 10 or 20 or 30? Where does that precedent? It's not quantified anywhere, and unfortunately, there is no right to a view. I will further say that there is no 5th floor being proposed. I'm not sure where that came from. And these properties, given the level of damage they received, will be required to comply with current building code and fire code. All of these properties are going to be sprinklered. They are going to have proper fire separation at the party wall. They are going to have proper fire separation at the ceiling line or at the roof line as per NFPA in the IRC. I did look in my notes. We did actually receive a board approval from the Canton Community Association. The vote was 7-2 in a support. So we did present publicly to this group and received overwhelming support. I can provide it for record, but in my notes it said 7-2. But I can reach out to Doug Kaufman and get an actual document from them that would be sent directly to Ms. Wood.
All right.
Mr. Carabello.
Yes, sir.
That was significant. At least there was testimony from the opposition about fire risk, about building higher. They also testified about, anecdotally, about the fires that end up destroying those properties, how it results in a difficulty for emergency personnel to reach the buildings.
Mm-hmm.
Can you speak about whether or not you think that how these buildings will sort of mitigate any of that risk, or just speak to you generally about the risk of building higher with fire?
Well, certainly. Existing buildings generally do not have a lot in the way of fire protection to them. Current building codes, the International Residential Code, the NFPA, does require that a building that has sustained the damage that these 4 have does require an automatic fire sprinkler system. It does require a 2-hour fire separation at the party wall party wall area. It also requires 2-hour fire separation at the roof line within 4 feet of the property line on either side. These properties are going to be built to current standards, which do mitigate and limit the effect of fire damage to not only that property, but the adjoining properties. Whereas properties that were built 100 years ago have virtually nothing.
So would you say that it's actually improved?
It's greatly improved.
Okay.
Because there are actually systems in place.
Okay.
Whereas, existing buildings have virtually nothing in the way of existing systems.
Okay.
Even the brick walls in between the buildings, a lot of times those brick walls stop before they get to the roof structure itself, and there are gaps in between on the property line.
Okay.
It makes for fires that spread very, very quickly. In this case, this is actually a much, much safer building.
Okay, thank you.
How much of the project you've described to us has already been built?
For the first time today, I heard that anything was being constructed.
All you gotta do is look at it.
I'm the architect, I'm not the
Okay,
Okay,
folks.
we can't.
I'm not
peanut
aware of
gallery
anything being built
commentary, okay?
on site. The developer can speak to that. But I'm not aware of any construction currently.
Are there any citations on the property, project? To your knowledge?
To my knowledge, no. And I know for the 3 buildings that I designed, there is no construction currently being undertaken for those 3 properties that I'm aware of.
Who's the developer for what has been built already?
They're accusing that 1210, that's Brian Chance as the developer. Again, I have no knowledge of any, he is not here, no, so he can't speak to that.
So apparently he's building it without zoning approval?
That's what they're accusing, but I'm not aware of any construction currently.
Hey, everybody needs to speak into a microphone that is on, and you can't shout from the
I know it's emotional,
the
but
seats.
come on, you gotta rein
Thank
it in.
you.
Yeah, I'm not aware of any construction going on. It's possible, I'm not saying that it's not happening. I'm not personally aware of it. So I can't say yes or no under oath that it's occurring. Because I have not been to the property probably in maybe a month.
Okay.
Can you get building permits without zoning approval?
Yeah, you're just rebuilding your house in the same way.
Yeah, you still
Can you all
need a
talk into the
building
microphone,
permit to
please?
build anything there. So, if there is construction happening, it shouldn't be happening right now. They need to go through the proper channels, obtain this variance, obtain their building permits. So if there is construction, someone should call 311 and report it.
We did, sorry.
Okay. Any more questions for Mr. Carballo? No?
No.
Anything?
I have a question. 1216 is the property you're responsible for?
I'm the architect.
Right, but do you have no knowledge? So that's 1216, the 2-story building,
sir?
which now has 4 floors.
Come on up.
Yeah,
You're Mr. Palmer?
Yes.
Okay, just want to make sure I have.
that's 1216. It used to be a 2-story house.
Hold on. The way this proceeding goes is the appellant goes, the opposition goes, and then the appellant comes back.
Okay.
The information is important because we don't have Mr. Chance here who can, I guess, comment on certain things. But I'm going to allow you to at least present this information. And your testimony is that what you're showing to us is a photo of 1216
That's correct.
South Highland.
Correct.
And when was that photo taken?
This was taken 2 days ago.
Okay.
And
Okay, we need to have him speaking into a microphone. And the board's practice, although has not always been consistent, is that we can't look at documents on phones or screens because then that does not become part of, we don't have it as part of the record.
Understood, but you
moving
have printouts that were handed in by my neighbor that also shows the
these.
same pictures that I think are a little bit older.
Okay, so what we're gonna do is we're gonna look at the evidence that we have. I thought it was important to at least hear
Thank
what
you.
it is you're saying, although it's taken out of order, and we'll give Mr. Carballo an opportunity to respond. But again, any information that's gonna be a part of the record has to be formally made a part of the record. So if you do have a set of photos, if you're
If you have a printer
suggesting-
here, I can print this out and put it part of the
I don't-
record,
that's
or
not-
email it to you.
That's not
Actually,
on us.
he should email it to, for it to make it to the file, if we're going to consider it and discuss it. Right, that's right, Becky?
Yeah, it's just that
We are allowing this in for the limited purpose that the person working on the project isn't here to testify about the state of it, and there are strong indications that there has been some work done on it. Whether or not that's dispositive or even, we consider it in our decision, it still is. There's a person here who can correct something that's on the record or
It's a
clarify.
fact.
Yeah.
It's part of the testimonial record, and if at all possible, we'd like to have the accurate, factual record before us. Again, whether it's dispositive or not, or whether it's, goes to the issue of the decision. So, thank you for that. Back to Mr. Carballo.
Thank you.
And Mr. Carballo, I'm aware that you're not supervising on-site of the project, so.
I'm not a construction manager, I'm not building owner. Mr. Chance certainly didn't, contact me stating that he was doing any work on site. As I said, I probably haven't been to the site itself in maybe 3 or 4 weeks. I'm not aware of any, but I think that's neither here nor there. I mean, we're here not to, if there's an issue with people building things without a permit.
There's a process.
There's a process for that that is separate from what we're here before you today.
All right. Anything further from you, Mr. Carballo?
No, sir.
Anything further from you, Mr. Dixon?
Yeah.
Yes, sir.
This is a
And
second.
any further questions for these gentlemen?
None from me.
No. Could you speak more about there was testimony that you do not meet the qualifications for being within the middle of a block, I believe?
Mid-block property.
Mid-block
definition of
property.
Mid-block property.
What's your understanding of what that definition, how this property applies, how this exemption applies to this property because it's the mid-block exception?
Well, it's simply properties that are in between 2 named streets. Even if
it's an end unit, it still will qualify because
it's not on a named street. What they're referencing is at the corner of Elliott and South Highland, there is another property at the end that turn 90 degrees. Those properties, the north.
And there's the alley.
They front Elliott, and then the property behind it is basically a shared driveway.
Understood.
It's not Main Street.
Becky, what is your understanding of how that exception applies?
Right, I think I would agree with what Mr. Carvalho said, that that is how interior is interpreted. Also, if it were on the corner, it would still apply, they would still be able to get up to 45 feet by conditional use if both of the roads on that corner are 30 feet across. So it's not like corner units are excluded, it's just that interior units they only have to have that 30 feet wide street in between, whereas on the corner, both streets have to be. But in this case, I think it is still an interior lot, even though it's an end unit, because it's not on 2 streets. It's not on the corner of 2 named streets.
Okay.
Okay, anything else for Mr. Carballo?
No.
All right, thank you, sir. Thank you. Thank you. Thank you all. Do we feel like we need any additional information that haven't been presented to deliberate on this? No? Anybody feel that way?
It seems like you do, if you're
Well, I mean, we don't have
This is always
Mr.
the-
Chance, but that's, I don't
Neither
think
here
that's a
nor there.
dispositive issue. Do you think you have everything you need to rule on this?
No. I'm ready to rule.
Okay.
Yeah. I'm sorry.
You weren't listening to the question?
No, I was not.
let's talk about it.
So wait a second. I think the first issue is, are we considering all of them together, or does one have separate issues than the rest?
Well,
Or several have separate issues than the rest?
the testimony that I heard generally all went to height. There were issues raised about height. There were issues raised about safety.
Because of height?
I'm sorry?
Safety because of height. I think everything stems from height.
Correct, correct.
Yeah.
And there's one involving a conditional use.
Oh, with the garage? No.
The 12,
Oh, is it a conditional use height thing? Is it still-
1216, yeah, maximum height.
It's the weird height conditional use.
All 4 of them are, the height for each one is through that conditional use process. So I just wanted to make sure that that is what applies to each. The conditional use standards are what applies to the height for each of those properties, even though technically the heights are different. Anything between 35 feet and 45 feet is by conditional use.
So you said what? So none of these are height variances. They're all just conditional use for that height range that we, okay.
So the conditional use standard applies across the board to all of them.
Am I on glue? Is it not in here?
I didn't hear anything. The one thing I heard that this approving this use would be contrary to the public health, safety, or welfare was about the potential of fire risk.
Yeah.
But now that these properties are going to be rebuilt pretty much from the ground up, not because of the fire, it's actually going to be enhanced fire safety. So I think I've heard testimonies that sort of outweigh the opposition's testimony. Also, now that I think about it, as much as we love our waterfront views, anytime a rooftop deck is built in the city, a small bit of the view is going to be obstructed, a little bit of it. Whether it's a view of, the National Shrine at Fort McHenry, or if it's a view of a public park, a little bit of the view at a time is going to be obstructed. That's part of what happens.
You
and I
can't
understand-
buy a property on land and expect nobody between your property and the
To ever
water
want
to
to
build
change it.
anything.
Yeah, and I understand the idea that those located a bit, that because this property is on a hill, that a lot of the development has been stepped down, so that means that people who are a bit north of these properties, their view is going to be obstructed, while people who are a bit south of these properties might still have that view. But that's a private property interest, and with the conditional use standard, we're really interested in what will be detrimental to the public interest, and I haven't heard anything today that has stated, well, how would this be detrimental to the public interest? A rooftop property here as opposed to putting a rooftop property anywhere else. These are the same problems that you'll see whether you build a rooftop deck in here in this location in Canton, or a few other blocks in Canton. A bit of the rooftop, a bit of the view will be obstructed. That's just a part of how this happens. It's just, but so I'm inclined to rule in favor.
Okay. I'm in agreement, looking at again, since we're constrained by the conditional use approval standards.
Wait, before you.
Go ahead.
I'm looking in the memo that was prepared for us with for 3 of them, it says variance. You're sure? It's just, you wrote it just in the variance? For 3 of them, it says variance, and for 1 of them, I just want to make sure we're absolutely sure that this is
Right, so the heading there is
Yeah.
not quite right. So it's a conditional use and 2 variances for 1212. It is, let's see here, a conditional use and 2 variances for 1214, just the conditional use for 1216, and then for 1210, I lost it.
1210 it says you have 3 things. One says conditional use in quotes, and the other both say variance requested. All of it's under variances, though.
Yeah,
Okay.
so it should say conditional use and then two variances below that.
Okay, just making sure.
Well, then go with that. With regard to the variances,
So they're all asking for the same variance. So we can apply the variance standard right now. I'm sorry, they're all asking for the same conditional use for height. So we can talk about all 4 kind of as one, because it doesn't matter how much each of them is looking for, because it's not a number or percentage variance, it is a conditional use for height. So those are the 4 questions you were about to, I'm right? For all the,
Correct.
all,
For the height issues,
so 10,
Yes.
12, 14, and 16 are all requesting a conditional use for a number above the maximum height. And for conditional use, we apply, I think we skip to the Schultz, I can't say those names together without sounding ridiculous.
I agree. That's the only reason that we could deny the conditional use with the Schultz standard.
Yeah.
And basically what that says is, in order to deny the use, the board must find that facts and circumstances indicate that the particular conditional use and location proposed would cause an adverse effect upon adjoining and surrounding properties, unique and different in kind and degree. So the question is what the opponents are bringing up, does that cause that adverse effect?
No matter where it is in the zone, is that it?
Well, it says adjoining, I don't know if these are adjoining.
well,
A couple of them were.
the adverse effect is the obstruction of views
Yeah.
as a consequence of the height. And we've had cases,
With
a
views.
ton of cases, with regard to issues raising impact on views. And I think the conclusion has always been there is not an entitlement or right to a view.
Yeah.
Yeah, I don't think it meets the Schultz standard.
Yeah, and I think it falls short of that.
Yep.
Because there's nothing codified in the code regarding the right to a view, or that there will be no building from the time you purchase your property to, it is a risk. And I think the board and its decisions have interpreted that issue consistently, that there is no entitlement to a view, and therefore it can't be an adverse impact.
So then it's the 4 questions, right?
Yes.
Would the establishment, location, construction, maintenance, or operation of the conditional use of that extra height be detrimental to or endanger the public health, safety, or welfare? I think Leland said it very clearly in that these are, as newer buildings, they are more fire safe than the old ones. And there's no other health, safety, or welfare issues that were brought up, like trash or whatever else a person might consider. Second question is, would the conditional use be precluded by any other law, including an urban renewal plan? There's no evidence of any of that. Would the authorization be contrary to the public interest? I think this is the one that is probably the biggest sticking point here, and it is a person's view from their home, a public interest thing. So I'm gonna put a pin in that for a second and let someone else answer it. And then, would the authorization be in harmony with the purpose and intent of this code? The authorization of building back newer buildings in place of old ones that were burned down, I think is absolutely in harmony with the purpose and intent of the code. So number 3 is the one, I think, that is the sticking, basically the crux of the issue is that, and I think everyone's addressed it, in that you're not entitled to, having a view from your house is not a part of public interest.
Yeah, I think it's a private property interest.
Yeah.
The waterfront view. This isn't public property. These are people's homes who, they purchased it, loving that view. I understand it, but that's private in nature, not public.
Yeah. I mean, can we move to the vote?
For those reasons, I would vote to approve the conditional use for height for all of the 4 properties. Did I say it right? The conditional use of height for all 4 of the properties, 1210, 1212, 1214, and 1216 South Highland.
I agree for the reasons stated.
That's what
I also agree for the reasons stated.
Now we have to get to the other, I think in this case, we have to take each one individually now, because it's,
They differ.
yeah, each is asking for a different. 1210 is first, and the other 2 variances that 1210 is requesting are a minimum rear yard setback and a maximum lot coverage. That's the actual variance standard. Honestly, we might be able to add all of them together because I don't think that there was any evidence presented by anyone in opposition that they were, and correct me if I'm wrong, members of the board, there was, nobody had any issue with a setback or a lot coverage for any of these properties, correct? If anyone else
I think only in relation to fire issues that were brought up, but they've been addressed.
Yeah. So maybe we can take them all together.
And also, a lot of these were built in the same footprint.
The previous houses or the new ones?
Well, some of the new ones, one that I thought I understood the testimony to be, strike that, because I'm not exactly clear on that.
Well, 1214 and 1216 are both asking for the exact same lot coverage and rear yard setback. So they're both asking for a 40% variance in lot coverage and a 25-foot variance in rear yard setback, because that's where you get your same footprint from for those two, 14 and 12. 16 is not asking for any other variances, so we don't have to worry about that one. And then 1210 is asking for a 3-foot 2-inch rear yard setback and a 21%, so a little bit less than the other two. A lot less than the other two, actually. Half of the percentage in lot coverage and a fraction of the rear yard setback, probably because it was already a setback. So I will go through the variance. So I'll just consider them together, and if there's something individual about one of those three properties, 1210 or 12 or 14 that someone remembers, stop me. So are the conditions on which the application is based unique to the property for which the variance is sought and not generally applicable to other property within the same zoning classification? Y'all know my answer to this. It's exactly the same as the house. Literally, if we're considering all three of them together, it's exactly the same. These conditions, there's nothing unique about this. This is the kind of thing without neighborhood opposition, it would have gone on the consent docket.
Okay.
I agree. If we could just, we gotta reevaluate those standards. In the process.
There's not an unnecessary hardship or practical difficulty to building it, this is just a desire for a bigger home.
So you all could approve part of the application and disapprove part of the application.
Because the conditional use standard is different than the variance standard.
Yeah.
I think that I am of the mindset that we can approve the conditional use for height, but I don't see where there's anything unique about these. I mean, the evidence is right here. Like, if we can group these three properties together, we can ungroup them, but it's just a simple comparison. Two of them are asking for exactly the same variance, which by definition makes it not unique.
Okay, did we, want to be sure we're clear on the record of which properties with regard to the variance issues are we able to,
So
you're saying we're not able to grant any of the variances?
I don't think so. I think the only
1216.
1216 is, I think we can grant 1216
Oh, right.
outright. It's only asking for a conditional use for height. It meets the conditional use standards. I agree that, there's no blah, 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 but that it's not fair. There's no endangerment to public health, safety, or welfare. It's not precluded by law. It's not contrary to public interest, and it's in harmony with the code for 1216. It's only asking for that one conditional use. For the other three, for 1210, 1212, and 1214 South Highland, same thing with the conditional use for height. it meets all the requirements for the conditional use standards. And it, we can't deny it under Schultz-Pritz. So, but for those other three, for the variances that are being requested, they are not unique. There are no conditions that this application has stated, no matter how wonderfully presented Mr. Carballo's presentations always are. There's nothing unique about any of these three properties. And it's actually what they're asking is generally applicable to other properties within the same zoning classifications, including the neighbors attached to it.
Something that the board could consider is that if that information wasn't presented today for the variances, certainly the applicant could always ask for reconsideration.
Good move to
If,
reconsider.
but they would have to follow the rule for reconsideration, but I'm just putting it out there that that's possible.
I couldn't hear what you said, Peggy.
Oh, I just said that if the board, first of all, if the board wants to approve part of the application and deny part of it, you can do that, especially because in a couple of those cases, those setback variances relate to the creation of garages. So, they could still go up with the height, but not use the variances for those garages. The second thing is that there's always reconsideration if the appellant wants to request reconsideration afterwards, they could do that under the board's rules. So I just wanted to point that out as an option.
Yeah, that's true. So.
Do you want to vote, you want to call each one
Yeah, well, I'll do
separately?
that. So case number. Let me do it this way. Docket memo has the better thing. Case number 2022-391, 1210 South Highland Avenue. I have a yes as to conditional use and a no as to minimum rear yard setback and maximum lot coverage variances.
Which one is this?
2022-391, 1210 South Highland.
I agree with that.
I do also.
Yeah, I'm also a no on the variances for that property, 1210 South Highland.
All right, 1212 South Highland, 22, well, let me do it the order of the cases, 1216, not sure that this way, 1216 South Highland, which is 2022-396. That is solely asking for a conditional use. For the height, I'm a yes.
I'm a yes
I'm a
for the
yes.
reasons I cited.
Yes.
All right. Case number 2022-397, 1214 South Highland. I am a yes as to the conditional use and a no as to the variances for maximum lot coverage and rear yard setback.
Yes, I'm the same.
Yes.
And case number 2022-398, 1212 South Highland. I'm a yes as to the conditional use and a no as to the maximum lot coverage and rear yard setback variances.
Agreed.
Yes.
Yes.
Okay. That concludes the matter.
Jeez.
Thank you.
You just looked over the variances.
I don't know.
Nobody scored it up.
If you presented it, you
Nobody
could
brought it
have supported it, so I think it'll be on reconsideration. All right. Let me just be sure I get this. Consent document. No.
Process.
I understand, sir. Thank you. 396, 396. All right, Mr. Barry. Recalling case number 2022-359. Are there other matters or just this one? This particular property, or are there other addresses that you're here for?
No, these two and the other one.
Okay, well, the other one is, all right.
So 403 and
There's two properties next to each other by the same developer.
Okay.
359.
They're asking for different things, so.
All right, well, let me just call them formally. 2022-359, 707 through 709 Druid Park Lake Drive, AB Associates. This is a request to use the premises as 11 dwelling units, variance requested for off-street parking. And case number 2022-403, 701 Druid Park Lake Drive, AB Associates. Again, variance to bulk regulations to alter interior for 20 dwelling units with 12 off-street parking spaces. All right, Mr. Barry, that's correct for both of those? I'll hear from staff and planning with regard to those two matters.
Okay, so for 2022-359, 707 to 709 Druid Park Lake Drive, there are two variances being requested here. One to off-street parking, 5 spaces required, 3 spaces proposed, 2 space variance requested, and also for minimum lot area, 7,875 square feet is required, 5,645 square feet exists, so it'd be a 2,230 square foot variance requested. The last legal use of this property from our records is a multifamily dwelling with 6 dwelling units, so they're adding 5. Planning had a lot to say on this application. The Department of Planning recommended disapproval of the application because the lot area variance is large, and their main issue, besides the fact that the lot area variance is large, is that according to the plans that they reviewed, there is no easy access to the rear of the property for the tenants to dispose of their trash. So in my conversations with Martin, he was talking about how tenants would have to go out the front door of the building and kind of around the block a little bit to get to where the trash, dumpster would be, which planning thought was going to be a problem in terms of sanitation issues. So that is planning's main concern. And then I'll go to the other case. So this is 2022-403, 701 Druid Park Lake Drive, right next door, I believe. 2 variances being requested. 16,500 square feet is required for minimum lot area. 10,500 square feet exists, so it'd be a 6,000 square foot variance. And off-street parking, 20 spaces would be required. 12 spaces are proposed, so it would be an 8-space variance. The last authorized use of this property is as a multifamily dwelling with 9 dwelling units. So the appellant is proposing to add 11. There's a letter of opposition in the file from Stephen Mowbray that says that he is in opposition, but he did not give any reasons why.
What was the last name you said?
Stephen Mowbray, Mowbray.
Do we have any live opposition here? Okay, we're gonna have to, you all gotta be sworn. Stand up.
Raise your right hand. I'm just waiting for the gentleman. Anybody who's going to testify in this matter, if not, do you solemnly swear or affirm under the penalties of perjury that the testimony you're about to give, the statements made, and responses given will be the truth, the whole truth, and nothing but the truth?
Go ahead, Mr. Barry.
Okay, let me first direct your attention to this rendering, which is obviously an architectural representation of how the buildings are proposed to look after renovation. There are 2 large multifamily buildings at the gateway to Reservoir Hill, Park Avenue, and Druid Park Lake Drive, across from the reservoir. And if you have the ability to pull up Google Earth, you can look at these. You can look at these buildings, which are badly deteriorated, exterior and inside. They have been for, I think, 10 years is a reasonable guess. And the proposal by the developers with me today is to renovate these buildings, not adding any additions, but using the existing structure, and the buildings will be applied for historic tax credits, so there will be both exterior and interior renovations have to go through a strict review. Now, there have been several issues, and several of the members of the community are here, which we met with over a week ago. and I want to at least address those points to you. In terms of parking, planning, and I wish Martin was here because he's heard this complaint before. We reach out to them, we don't hear anything from them until the day of the hearing. And so the ability, his suggestion at one point was to go have an extra, right now there's an existing driveway and curb cut between the two buildings, which is going to be used for trash collection, is also going to be used for access to the limited amount of parking that's available in the rear of the property. We've given planning and the board those site plans. We can only do so much. Can't tear down the building. The building under the zoning code is over 50 years old. It's really allowed to have an historic parking exemption, but we're asking the board for a variance because the new zoning code's being adopted. It's going to modify that process somewhat, but it's just passed last night.
Where's the curb cut?
The curb cut is in between the two buildings. There's a driveway that goes back to the back of the building. You can, it shows on,
You have to wait until it's your turn to talk, and then you can.
Okay, gotcha.
it is admittedly a narrow entranceway. Planning suggested that we go in off of Park Avenue. Unfortunately, that would involve the removal of a beautiful tree, which is on the curb, and which we heard from some of the neighbors, if they want to comment on it, that they would like to keep that tree, and our plans call for it to be kept.
This is the tree in the picture?
No, that's, no, it's on Park Avenue.
Okay.
So the parking is what it is, but more importantly, from our observation, we may have some disagreements, there is now parking on one side of Drew Park Lake Drive because of the barriers, if you see in your, for the big jump and the construction that's going on along Drew Park Lake Drive itself. So the Department of Transportation, we met with them, and they have told us that when those barriers are going to be removed, which is going to be, I don't know when, but it's certainly not going to be in the immediate future, but this building's not going to be ready in the immediate future, is that they intend to provide off-street parking on both sides of Drew Park Lake Drive. Now there's only on one side, and frankly, from our experience, it is underutilized completely. So they're not only there, but on Park Avenue, there is, we believe, more than sufficient parking. And building is not in the middle of the neighborhood. It's at the edge of the neighborhood by the expressway. It's on a bus line. We think it's going to be attractive to MICA students, professionals that don't necessarily need cars. The board has certainly granted variances to reduce parking in similar situations. We asked you, we can't provide any more parking, but let me get to the density variances, which I think are more important for you. The floor plans, this was a different building than what the typical Reservoir Hill building is in R8, which are large row houses. We're not asking to put an addition on this building. We have the structure of the building itself that can only accommodate certain types of units. These units, for example, the 701 building is over 10,000 square feet. That's a very large building. 707 is over 15,000 square feet. And to take the structural walls that are inside that building and lay them out in an efficient way results in apartments which are large by today's standards. 701, the average square footage is 772 square feet. That's a large one-bedroom apartment. It's over 750 square feet for 707. We have units ranging from almost 500 feet to 900 square feet. So we're not squeezing in as many small units as possible. We're taking the structure of the building, it is what it is, and have a reasonable amount. That we need a density variance for both? Yes. Do we need a parking variance for both? Yes. But we think the structures are unique enough, and certainly you can see you have a mixture of buildings all along Drew Park Lake Drive, from the elderly building, which is the high-rise right up the street, to some single family, and these two buildings, which deserve to be renovated in an historic way and be a gateway to the community, which it will be. They'll be the most prominent buildings coming across from east to west. So Another issue came up about garbage collection. There are going to be two separate trash collection screened in the building, and I take exception with planning's report in that one of the buildings will have rear access for trash, so people can come down in the building and go out the back to one. The other building will have a trash collection on the side, and that's less than 100 feet away from the front door.
Which one has access from the back?
707, which is the
Second
further
building.
one.
This is the further one here.
Gotcha.
Yes.
And so the folks at
We're not
701,
relying on the city. It's going to be professionally managed and have private pickup. It'll be screened. The design of that, obviously, would have to go through the building permit review, which planning looks at. But I don't think it's an unusual situation. The Reservoir Hill complaints that I've heard consistently when either some of our appeals and others over the years has been that you live in a row house and they can't get out the back and you have to walk all the way around the block. That's not the case here. You have to walk less than 100 feet out your front door. You might have a parking space in the back you're going to go to anyway, but it's not inconvenient to walk through that driveway between the two buildings to get to deposit your trash, which will be picked up by a private service.
You asked the question.
well, so that coming out of 701, you'll come out of the front and go to the left and go to that driveway
Yes.
to deposit trash.
There is
You have to identify yourself and speak into the.
You can grab a mic.
Yeah, here, speak into introduce yourself.
Sorry, gentlemen. My name is Pavel Kazanov. I'm the developer.
Go ahead, you spell that, sorry.
Sure. First name Pavel, and last name is Kazenkov. Thank you. I just wanted to
You
put.
need to get around the mic. You can pick it up and take it with
Got
you.
it. I don't want to break
As
this
long as
thing.
it's green.
Oh, sure.
Yeah.
Copy that. So 707, as the gentleman asked, the exit is in the front and the back, leading out to the parking lot. 701, which is this building here, there's a door here, and there's a door on both sides, and the front entrance. So there's three entrances.
Okay, so the trash deposit on 701 is in between the buildings?
So it'll be back here, and then also in between these buildings. So there'll be two sides.
Okay. And did you say there was a side door?
Yes, sir.
So you don't have to walk out the front and go around to
That's
the
right.
side?
You can go on the side door. That's right.
Okay.
Now, we made that decision hearing some of the comments from the neighborhood, because otherwise we were going to close off one of the side doors, but because we're still finishing that up, we wanted to leave that open.
Okay.
So I'm anxious to hear some of the community comments on this. Again, we met with them over a week ago. We said the plans somewhat, we would look at again in terms of trash collection. We think they're unique buildings, certainly within the R8 that you see in Reservoir Hill. They're large buildings. We're not adding an addition onto them. And we believe that, we hope the board can approve it, but I'd like to hear what other comments the neighborhood has.
Let me stay with you for a minute on the uniqueness. And is it your contention, your testimony that uniqueness, among other things, is manifested by the age of the buildings, the way they're constructed, the supports inside the buildings? You mentioned that the way
the buildings, as you can tell, are wide buildings, and so there's structural bearing walls that cannot be removed as part of the renovation.
Okay.
And so that lends itself to a certain degree of how the units fit into those walls and where hallways can be and so forth. And so we have a range of units. Obviously, it'd be nice if all were the same. There are a range of units from 450 square feet at the small end to over 900 square feet at the large end, but the average size is, frankly, larger than some of the units you may look at in other cases. 672 square feet in 701 and 750 square feet is the average. And again, many of them are that size or more. So.
Good. Thank you.
Good afternoon. My name is Thomas Cujo, C-U-D-J-O-E. I'm a physician and public health researcher at Johns Hopkins, and I state that I live at 2216 Park Avenue with my family, my children, and I come here today. We are happy that they are developing this vacant property, but feel, or from my family standpoint, we feel that it needs to be done in a proper way to mitigate public health concerns in terms of sanitation. We currently, in many parts of the city, have rat infestations due to poor care of refuse, garbage. And my big concern here is to ensure that proper egress from buildings are such that allow for residents, whoever they may be, to properly dispose of their trash, and that the managers and owners of the building have proper things in place to ensure that refuse is taken care of appropriately. And so that is my concern, that the record reflects these comments and that the plans that have been proposed actually in writing yield to the appropriate standards of proper size of trash facilities and proper plan for maintenance of these facilities over time. That's my big concern
Okay.
that I wanted to state today.
And as you've been sitting here today, sir, have you heard anything that assists you in determining whether or not this project is in line with those concerns that you have?
Mr. Barry and Mr. Pavel, I can't pronounce his last name, have come to us, but I believe the plans in terms of the actual architectural drawings, which I've seen, don't reflect to me proper egress to access the trash cans.
And what would proper egress be to you?
Easy access to trash can and proper maintenance and enclosures.
Okay.
You know the policies and procedures better than I do. For the amount of units that were there will be a lot of trash. And so I want to ensure that there's proper spacing based on whatever ordinance exists that you are aware of, and ensuring that the codes and things are enforced for the number of units that are expected to be there once they redevelop the property.
Okay. Thank you, sir. Gentlemen?
Good afternoon. My name's David Sargent, and I am Dr. Cujo's neighbor. I live closest to this property on Park Avenue at 2224 Park Avenue. The first thing I want to clarify, and the first thing I have objection to, is that we're looking at, on the docket, we've listed both 707 and 709 as one property. Is that your understanding as well?
We understand that to be the property address is at issue.
So technically, there are three buildings that we're talking about, correct? Three. So you have 707 and 709. Is it not that the alley here goes between both 707 and 709? Sorry, I'll pick this up.
701 is separated between 707.
Yes.
Right.
And
And
then
709?
707 and 709 appear to be the same building, and then the one that's what's next to
The
them
second
is.
building, correct?
Yeah, and then what's next to that, the next one I can see is 711. 713, because I can see 715.
709 and 711, sorry, 707 and 709.
Correct.
Yeah, do you want to see it on the Google map?
Yes,
I mean, you live there, yeah.
Is that the building that we went into? It only shows one address.
707.
Okay.
Sir, go back to the mic.
So you have to speak into the mic and talk to them and not, yeah,
Okay.
not to Al, yeah.
So density variance is quite substantial, and the person who's representing here, the developer, I don't know if it's like, for me, when they say there's not going to be an addition to this building, I understand that. They're not building something they're not adding to an existing building. But what they are doing is they're adding significant density for an area that's currently under a lot of construction, as you can see. I'm concerned mostly probably for my neighbors who raise families here. I'm concerned as well that my neighbors include two churches that are well attended. And you know, for example, so on Sunday when I got back from church, I couldn't park on Park Avenue. I had to park on Mount Royal and walk home. It's only on Sunday, but it really gave me a sense of what parking might be like when we put 21 units at 701 and another 11 at, or sorry, 20 at 701 and 11 at 707, 709. The Department of Transportation has done a lot of studies with regard to how traffic will come through that area once the Homeland Security finishes their project with the reservoir and all of that development. A lot of the planning and a lot of the things that we're seeing from them don't really address this specific area. If you were driving a year ago or 2 years ago, you could turn off of Druid Hill Park and go right onto Mount Royal as like sort of like a cutoff. So what's happening now is we're getting increased traffic because of that cutoff, and they're coming out in front of the senior citizen housing, passing where this construction will be, and turning either down Park Avenue or, so it's increased traffic, increased density. Realistically, if you're looking at market value apartments, I feel like a young couple starting out maybe would like those apartments. Reservoir Hill's a great area to live. That's why I chose it. I feel like that young couple probably has 2 cars. They may not work in the same location. I say parking's not a problem until it is. And I feel like the number of units that we're increasing from 15 to 31 is more than double in size, double in the amount of cars, and it doesn't serve our community very well. Trash collection, I feel a building this size and of this density should have either on-site or a dumpster equivalent to what the standard is. What's proposed are individual trash cans. I disagree with that. And it just adds to the public health concerns for our neighbors. 2 of my neighbors who live next door, the Morgans and Miss Otelia, unfortunately they couldn't make it today, so we talk on a regular basis, and those are our concerns. Thank you.
Thank you, sir.
Sir, can I just ask you to spell your last name?
Sure, Sargent, S-A-R-G-E-N-T. Correct.
Good afternoon. My name is Stephen Mowbray, and actually I'm a resident of Mount Vernon, but I have been developing properties in various areas of the city. And I'm finding that they're requiring more trash rooms in developments of this size. And apparently, these developers are going to put, if I may, this is an alley, proposed to be an alley that will have, I guess, vehicle access to the back, or is it only pedestrian access to the back? And there's apparently a proposal that there will be trash cans instead of something which might be more appropriate is to have, if a truck can get there and back up and pick up a dumpster that is contained inside the building, then that would be more appropriate in a historic district. And I don't think anybody's really talked too much about the interior structure of 701, if I may talk about that. It was probably quite grand in its day with views of the reservoir. I mean, it's the very top of the hill of Reservoir Hill. Mr. Sargent actually, and Mr. Cujo. Sargent's the very last house on Park Avenue. And they're very historic minded. I mean, it's a historic neighborhood. I think they're good on them. They're getting the application in for historic preservation tax relief. I think that's great, but I don't think that many units is appropriate in 701 because I don't think the interior is totally damaged. He says, Mr. Barrett was talking about how the interior walls are still intact. They have every chance to put spaces in there that were grand like the original dwelling units. Probably had 8 and a service apartment in the basement for, you know. So they're in my mind, very elegant, historic building as far as 701. I'm not so concerned about 707 and 713, but even though they're restoring the exterior, I think you should consider the interior. That's all I have to say.
One question, sir. Have you been in either of those buildings?
No, but
We have in 707.
Yeah, I personally have not been inside.
Okay.
But from what the description is of the bearing walls, I know I've done a lot of this stuff, so.
Okay.
A lot of restorations.
Okay. Thank you.
Thank you.
Mr. Murray?
Just to clarify, the owner is proposing 2 dumpsters that'll be enclosed with screens, not individual trash cans. We heard that as a complaint.
Sure.
On the record, we would say that before the building permit is applied for, we will meet with the neighbors and give them, and our trash collection company, and meet with them and do a whole trash plan, whether it gets picked up once a week or twice a week. That sort of is worked out, depends on the size of the dumpster. So that, we're glad that one of the gentlemen admitted that the parking is not a problem now, but may become a problem in the future. And I would point your attention again to the plan that basically says we're maximizing parking on site. We try to reach the church and negotiate with the church. They have an easement in the back of the building and a vacant lot, which we wanted to frankly purchase and get access to it, but the church refused to give that to us. So they're parking on the street.
Forever, or we try to negotiate it every once in a while?
Pardon?
Has the church
Oh,
just...
we've been trying to get their attention to negotiate
I was
with us.
just
So we've
curious.
asked the community to
Sure.
actually help with that because they have some relationships with the church. We're still open to that. And we would be able to provide additional parking with an access off the rear as opposed to that side. We'd prefer that, but we don't have that available to us today. So we had all the parking maximized on site. We have the street parking. Again, this is a building at the edge of two streets. It's across from a reservoir. It's not in the middle of a neighborhood that's generating parking on both sides of the street. And with the city removing the barriers that are on Drew Park Lake Drive, there will be as many as 20 additional curb spaces available essentially to these 2 buildings. They're the closest ones to them, or the church, and when they come in on Sunday, certainly. So we think the property is unique, large sizes inside. I think the idea that you could restore grand apartments that are maybe 1,500 or 2,000 square feet is not realistic in today's economic world. It's not the reason we're doing this. We're trying to fit the units within the structure. The bearing walls are there. There may be obviously some smaller partition walls that could come out. That'll all be reviewed as part of the tax credit application, which ones we're allowed to take out and which things we have to preserve. So I would hope the board would find its way to approve both of these variances today and let this building, which is a grand location at the entrance to Reservoir Hill be restored to what it was, is what you see before you.
Okay. To the extent you're able to get, always hopeful, any negotiations going with the church to acquire parking availability, how many spaces do you think that would provide?
Do you remember how many spaces we looked at in this lot?
So we had an original plan drawn that at one point included the church,
Yes.
because we did go through with them with the negotiation. They did not agree. I think we're looking at another, I'm on the record, I might be wrong, but I think it was between 3 and 5, I believe.
Spaces.
That's right.
Well,
20 spots, it's huge.
Again, we gotta talk to the board and only one person at a time. Thank you.
It's, if you look at the aerial of that, there's a very large vacant grass lot behind both of these buildings. The church fronts on Park Avenue. And we were hoping that initially we could have access through their property so that it would relieve access in that driveway between the two buildings. And in addition, we asked for consideration to put in parking on that grass lot. There's more than 3 or 5 spaces here, probably 15 spaces at least. But, and we're going to continue to negotiate with the church.
Right.
But
obviously you can't promise to have them if
we
you
can't
can't-
force them to sell to us or give us access even. Although the community pointed out that if we had access through the church, it would help with trash pickup for the buildings that are next to us further to the west.
You had a question?
You described a uniqueness for a 701 property.
Both 701 and 7, and they're unique in a sense of, if you think of Reservoir Hill, which is in an R8 district for the most part, it's made up of very large attached, some 2-story, some 3-story brownstones, as much as 3,000 or 4,000 square feet. This is building once over 10,000 square feet, another building's 15,000 square feet. So we're not converting a row house into an excessive number of units or adding an addition onto either one of these to gain more units. We're using the existing historic structures with, frankly, market rate apartments, high quality market rate apartments, 1 and 2 bedrooms. So we don't think we're taxing the building at all. It's just an anomaly of the R8 zoning for these 2 buildings. Maybe they should have been R9. Which some properties do have because they're larger multifamily. In this case, we were forced to ask for a variance, and we think the properties are unique enough to warrant it.
Thanks. The setbacks that you're asking for, the rear yard setback, let's see here. Oh, wait a minute.
No, I
I'm
don't think
asking for that.
there's no setback because the buildings
Good,
are what
because
they
I'm
are.
looking at the right property. Okay. 701.
There was one on York Road that might have had a setback issue.
Right, got it. So it's minimum lot area and on-street parking.
We'll go into that in 2 weeks, hopefully.
Okay. Any other questions?
No, good.
All right, thank you.
Okay, thank you very much.
Sir, I saw your hand raised, the way this works.
I'm not going to be recognized.
Okay. Okay, anybody want to take a stab at this?
Not it. Unless I have to be it.
Let's see.
Well, I guess my first question is, do we separate the two, or, I mean, we obviously consider them together, but what are the things that the two are looking for?
No, it's
It's pretty much similar, right?
They are.
Off-street parking.
And minimum lot area.
And minimum lot area, yeah. The only difference is the 707 building, last had 6 units and now they're trying to do 11. And the 701 building had 9 units and now looking to do 20. It's almost the same, right? It's about the same. I swear my degree is in mathematics and I can add when I want to, or multiply.
Okay.
Yeah, it's almost double in both of them. But it's a different kind of apartment. It's not the grand luxury. They're not trying to do the same, it's not the same business model. And the building, but I am swayed in the uniqueness for this one because of the historical nature of the building, because there are no additions being built, because it's on a really main thoroughfare, and those two buildings are definitely unlike anything else in that general neighborhood. And that's evidenced from the fact that if you looked at what's right behind the building is a church, and then two of the three people who testified who live on Park Avenue, one lives in a row house like me, and the other one lives in a single-family home, and that's all in the same block, right? So that makes this building far more unique than some other areas of town. And then right next to it on the other side is the senior high-rise. Yeah, and then some more row houses. So variances. So I think that the conditions are unique for these two buildings, and they're not generally applicable to any other buildings within the same zone. Number two, is there an unnecessary hardship if they don't get the, it can, basically, can these buildings accommodate, is it a hardship to create the extra parking spaces or to, yeah, it is. There's no space for any more parking spots, and then with the lot area, you can't make it any bigger than it is. The buildings basically cover the entirety of the lot. That's for number two, right? And I would say that the hardship is caused by the code, and it's not created by any intentional action or inaction of any person who has an interest in the property. For question 4, is not, as far as I'm concerned, well, and I guess this is a sticky one. I don't think that it's based exclusively on a desire to increase the value or income. I just think that people want different things from apartments these days than they probably did when those were first built a long time before I was born. Yeah, it's a different market. There are different people that are attracting a different customer base. For number 5, so will the variance be injurious to the use and enjoyment of other property in the immediate vicinity? Between the two, I think that the parking is probably an issue for that, if it'll stop people who already live there from being able to park. I don't think that 2 plus, they only have to provide, well, the code says it requires 5 spaces for one building. They're giving 3, which is more than half. So I don't think that 2 extra spaces for one of the buildings, or two spaces that don't exist for one of the buildings, and then 8 more, that one's a harder sell, but I still don't see it as an extreme sell, because people who, I know many, quote unquote, I'm gonna go with young because they'd kill me if they knew I thought they were old, but young couples that only have one car in downtown. I don't think that it's always you just make it work and you share a car and Uber everywhere. So I don't think that either of the two and then the minimum lot area variance, I don't think has anything to do with anybody else's use or enjoyment of their property, because they're not changing the size or shape of the building. And I would say that all 4 of the variances, 2 parking and 2 lot area, are in harmony with the code. There's no urban renewal plan. This doesn't address the city's comprehensive master plan. And from what Mr. Barry's been talking about, the historical and architectural preservation of this building is being addressed. And then, will it be otherwise detrimental to or endanger the public health, safety, and welfare? I think that's where the trash comes in, and I am more than convinced with the leaving in of the side door, of the gated in trash cans, and of all the meetings that the developers, the architects, and Mr. Berry have had with the community about how to properly dispose of trash that people live in this building will create, how to properly dispose of that. I think that issue has been more than addressed and is actually not done coming up with a solution that fits everybody. So it's clearly they're trying very hard not to endanger public health, safety, or welfare. So for all of those reasons, I think that both of the variances in parking and both of the variances in lot area for 707 Druitt Park Lake Drive and 701 Druitt Park Lake Drive should be approved.
I agree. I think meets all the approval requirements under the code as you described.
I agree as well. And it was also, I think it's an important fact of the location of the property, particularly 701, and the testimony that was presented regarding it's the gateway to the neighborhood, and that some of that parking is likely to be, off-street parking likely to be opened up with removal of barriers, and so the folks that are most likely to park in that area would be folks that live adjacent to that location. So I think that bodes well for the ability to find parking, and of course, everybody agrees that the church has an abundance of parking. Again, nobody can force them to negotiate, but to the extent there is a possibility that that could happen in the future as well, which would provide some additional relief. So, I agree for the reasons stated otherwise.
I also agree with the reasons stated, but also would like to note that there's public transit available on Drill Park Lake Drive, directly in front of the properties.
Would you like to put any conditions on the, I assume that you would want the sanitation condition on both properties, that planning usually suggests that they comply with the sanitation code?
Article 23, yes.
Anything else besides that?
I kind of want to make sure, I don't know how the best way to make this condition, but to make sure that all of the I don't want the discussions with the community members about the sanitation, about the trash to end with the approval, so.
They mentioned something about a trash plan. If there's a way we can provide a condition that they
Complete that trash plan?
yeah, and some sort of liaise with the local community organizations on that trash plan.
Okay.
Okay. That it?
Okay.
Are we done?
I believe so. We're off the record. Thank
Off the
you.
record. Thanks.